Justice.
Good morning. Good morning. How are you, Honorable
Good
President?
morning, Chief Justice.
Good
Morning,
morning,
Chief Justice.
Good
Good
morning,
morning,
Chief
colleagues.
Justice.
Good morning.
morning, Chief Justice.
Good morning.
Good morning, colleagues. Good morning. I take it that all the commissioners are in attendance now. I just want to take this opportunity to welcome us all back, particularly the Honorable Judge President Metalezi. Welcome, JP.
Thank you, Chief Justice. Good morning.
I also take this opportunity to welcome the Honorable Premier of the Northern Cape Province, Honorable Dr. Zamani Saul. Premier, I welcome you.
Morning, Chief Justice, and good morning, colleagues.
Thank you.
Morning.
Chief Justice, Judge Patswane is ready.
Thank you very much. Thank you, JP. Good morning, Judge Patswane.
Good morning, Chief Justice.
I can't see your face, so I'm unable to know whether, oh, now I can see you. Are you well?
I'm well, Chief Justice.
Yes. What degrees do you have?
Chief Justice, I've got BProc degree, LLB, and LLM degree, Masters in Human Rights.
From the University of the North, and the last two from Free State University.
From the University of the Free State. Chief Justice.
And what did you say your emphasis was for your LLM program?
It was human rights, Chief Justice.
Yes. And for how many years have you been a judge of the Northern Cape High Court?
For a period of 11 years, Chief Justice.
And before you applied for this position this time around, what leadership positions have you fulfilled?
What leadership positions have I fulfilled? Is that the question?
All right, maybe I could go ahead of you and say you were Vice President Programs of the South African chapter of the International Association of Women Judges.
That's right, Chief
Is
Justice.
that correct?
That's right, Chief Justice.
What exposure, if any, does that really give you to leadership responsibilities?
Chief Justice, I served as the Vice President Programs in the chapter. I was responsible for compiling the social responsibility programs of the chapter. That would be for one of the policies that had to be devised was the family dialogue program, and the health and awareness program. We participated in the World AIDS Day, and the 16 days of activism, Chief Justice. Chief Justice, I've got training, I would say, as a lecturer. The commissioners would have noticed from my CV. And with that training background that I had acquired, I used that in the chapter. We would visit, for instance, in Kimberley, the community of Khalishewe, where we would impart knowledge on matters, family law matters,
Okay.
and so on, Chief Justice.
Okay. No, thank you so much. You've acted as Deputy Judge President, am I right?
That's right, Chief Justice.
Now, what are the challenges in the division, and how do you see yourself fulfilling the role of a a dependable partner of the JP? What are you bringing on board? What skills, what leadership capabilities, if any, what managerial skills do you have on the basis of which you believe you suited for the position you've applied for?
Thank you, Chief Justice. Chief Justice, I've got 25 years post-qualification experience. The 10 years of that 5 post-qualification experience, I was a partner in a law firm, a director of a law firm. The previous time when I was before the commission, I gave details of what we had done in that particular law firm. But most importantly, I bring leadership qualities that I've acquired from that firm as a director onto the bench. Now, coming on to the bench, Chief Justice, I had mentioned that I have 11 years of experience on the bench, but the 4 years of that experience was in management. I've been the Deputy Judge President of the Northern Cape High Court at regular intervals. I've been the Judge President of the Labour Courts at regular intervals. When I calculated all the period where I have acted, I must also add that I've acted as the Judge President of the Northern Cape High Court, also at regular intervals. Chief Justice, there are various roles that I played as the acting judge president. If I may, Chief Justice, if I calculate the period in respect of which I executed the tasks rather of a deputy judge, it equals to 4 years of experience. There was a time, Chief Justice, just fairly recently, last year, where I acted as a deputy judge president for my court, the Northern Cape High Court, and simultaneously discharged the powers and responsibilities of that office in the labor courts as well, simultaneously, Chief Justice. And of the responsibilities that I have discharged, Chief Justice, as a deputy judge president, as we are enjoined to do in terms of the Constitution and the Superior Courts Act, I have to see to the sittings, determining the sittings of the court. I have to see to the assignment of judicial officers to those sittings. I have to determine the sitting schedules of those courts, where there are adequate number of judges in the division who may be absent for one or other reason, vacation leave or absence due to ill health. I have to see to it that I contact the office of the minister. The business of the court has to run urgently in certain instances, and request the minister or recommend rather to the minister to appoint acting judges in the division so that the business of the court runs. I have, Chief Justice, been responsible from 2014 to this day for case flow management in the division. And I must say that I did so with resounding success. If I look at the statistics, if I may, from the period that we started with our case flow management from 2014 onwards, to round off the figure, it's about 1,700 and so matters that were placed under judicial case flow management. Of that number, about 1,165 matters were certified trial ready. The remaining number of or so matters are still being case managed by the judges, Chief Justice.
Now, thank you, Judge Patswane. I realize you could go on and on. Let me not deny my colleagues the opportunity to engage with you. Colleagues, at this stage, before I call on the JP and the Premier, may I have the list of the names of colleagues who would want to put questions to Judge Patswane, please?
Lamola,
Magwanisha,
Muimang,
Nyambi,
Tepe.
Dodovu,
There was somebody before you, Honorable Dodoku. I just don't want to miss out on that.
it's Commissioner
colleague.
Singh.
it's Nyambi.
No, I've got you, Honorable Nyambi. You come before Commissioner Tepe.
It's
Chief
Commissioner
Justice,
Singh.
it was me after Nyambi Singh.
Did you
Thank
capture
you.
Muimang, Chief Justice?
I've got you, Honorable Mwiman.
Thank you.
Schlemmer.
Okay,
Right.
Prof. Sorry, who is that after Prof?
Reichenbach, please, Chief Justice.
Okay, thank you.
And Maya.
JP Mlambo, CJ.
Thank you, JP. Okay.
Did you note my name, CJ?
I did, President. I've got you right
Thank
here.
you.
Thank you. Is there any other colleague? The last is JP Mlambo. Thank you. Honorable JP, over to you, sir.
Thank you, Chief Justice. Judge Patswane, can you share with us your experience, if any, in leading appellate panels as a judge, either in your capacity as the deputy ADJP, AJP, or a senior judge on a particular matter? And what experience have you gained, and how would you in future take that forward?
Thank you, JP. I acquired a wealth of experience as a deputy judge president insofar as that is concerned, and that entails judicial leadership. Is Judge Patswane capable of providing judicial leadership? Indeed, yes. As a deputy judge president in the Northern Cape High Court, I've sat as a presiding judge where I have to give judicial a leadership in the sittings. But more importantly, in the LAC, that's the appellate court in labor matters, the decisions of that court goes directly to the Constitutional Court. But I also gave judicial leadership in that capacity. I had to sit as a presiding judge, surrounded by, on one side to the other, very experienced, astute jurists that I've learned a lot from, and that hold me in very high regard and respect me. And one of them, in fact, says, my impeccable character, my maturity, my integrity will be a boon to the leadership position that I've applied for.
So you never felt intimidated leading such huge giants men on the benches who were more experienced than you?
Not at all, JP. I've not been intimidated at all, as I say. They are of the view that my maturity will be a boon to the leadership position that I have applied for. I learned a lot from them, and that experience that I learned from them, I implement it even in my division.
I see. Would you comment on your relationships with your colleagues on the bench, and perhaps also include the practitioners generally?
JP, my relationship with my colleagues is very cordial. At the moment, we've got 4 permanent judges. Ordinarily, our bench would be constituted by 7 permanent judges. Of the four, it's yourself. We've got a formidable, we make a formidable team. I left my two sisters behind. My two sisters supports me entirely, and they wished me luck with my interviews, and one of them even prayed for me in that regard. One of our colleagues that just retired in December also this morning sent me a message to wish me luck. So to come to the question, my relationship is very, our relationship is very cordial, and there's collegiality in the division. And insofar as the practitioners are concerned, I can only say that they are of the view you would have noticed, both from the Law Society of South Africa and from the GZB locally. They are of the view that I'm responsive to the needs of the practitioners, and not only practitioners and the community, in the case of the GCB locally, the community of Kimberley. My relationship is very good, JP. Thank you.
Yes. And then regarding the magistracy in the province, did you have an opportunity to interact with them?
Indeed, JP, on a number of occasions. We do interact at the district court level with the chief magistrate. We do interact, and now and then the chief magistrate would request me. I remember at a certain stage, he requested me to come and guide them on the efficient court administration, and I went there and did so. So the relationship is quite cordial with the regional court president as well. We often meet in our PEEC meetings, where reports are made both from the regional court and the district courts. The relationship with the magistrate is quite cordial. In fact, I must also add that the regional, the chief magistrate similarly wished me luck with these interviews.
I see. And then at Sajay level, have you played any role?
Very much so, JP. It dates back from 2015, the relationship that I have had with Sajay. 2015, I was still a few years in the bench on the bench of the Northern Cape High Court. Sajay requested me to be one of the judges to participate in a program on the justiciability of socio-economic rights that was held at the Center for Human Rights, University of Pretoria. And I remember Justice Jacob was also attending that program. It was an LLM program offered by the center, or rather the University of Pretoria. And in that, during that program, I had to, because there were various judges judges from various countries, and only two from South Africa were contacted by Sajay to help. And I had to, in that program, talk to the justiciability of the socio-economic rights in South Africa. So the relationship dates as far back as that. But again, Sajay would now and then contact me, Judge Patswane, would you kindly assist us and with some training? I remember that last year they requested me to participate in a webinar where I had to give tips, share my experiences, best practices on judgment writing to the magistracy in Kimberley. I did so. And just fairly recently in this year, Sajay requested me to participate in the aspirant judges course. I also did so. JP had to give some training on the law of evictions and foreclosures. Thank you.
Yes. Thank you, Chief Justice. Thank you, Judge Patsone.
Thank you, JP. Honorable Premier.
Thank you very much, Chief Justice, and I'm certain all members know the fact that this is my inaugural sitting in such a meeting. I thought I was going to compensate that by just shutting up. But I just have one question which I want to direct to Judge Patsone. What's her conceptualization of transformative constitutionalism, its adjudicative implications for a province of the Northern Cape, and what would be the adjudicative implications thereof for a province like the Northern Cape?
The adjudicative process of, come again, Commissioner?
No. What I was asking is, how do you conceptualize transformative constitutionalism?
Right.
And number two, its adjudicative implications for a province like the Northern Cape.
Right. Premier, I will respond to the question this way. As judges, we are enjoined in terms of the Constitution in terms of Section 39 to interpret any let me put it in this way. When called upon to interpret any law, we have to do so in accordance with the values that underlie the open and democratic society based on human dignity, equality, and freedoms. And we have to take into account the international law, and we also have to take into account foreign law. That is when we interpret the human rights itself, if I may go back there. But when we interpret any other law or the Bill of Rights, Commissioner, when we interpret any other law or develop common law, or for that matter, customary law, we have to take into account the import of the human rights as are entrenched in our Constitution. Now I'm looking at the transformative constitutionalism in this way. As judges, that's how we will go about in the interpretation of law. But we have to be situation sensitive. That's very important. You interpret the law or apply the law being situation sensitive. And by that, it does not necessarily follow that you have to interpret the law looking at a particular constituency. We have to apply the law impartially, without fear, favor, or prejudice. And we have to look at the social context. We have a history as a country. That social context is important. Thank you. In a transformative environment, the judges should be alive to these issues that had affected the majority of the people of South Africa and be situation sensitive. Judge in the social context, but not forgetting that at all costs, you have to look at the Constitution and you have to look at the law, because this country is governed by the rule of law and the Constitution as the supreme law of the country.
Honorable Premier, do you have another question?
No, I'm covered. Chief Justice. Thank you very much.
Yeah, thank you so much. Honorable Minister.
Thank you very much, Chief Justice, and good morning, Judge Patswan.
Good morning, Minister.
My question relates to the fact that you have acted in the division for quite some time, including at the Labour Court. Have you been involved in efforts to modernize the administration of the division and in these years that you have acted? And if not, why? And if you have done so, what do you think you are going to contribute to more efforts to modernize into the division going forward in case you are appointed into this position? How will it benefit that context of modernization?
Minister, modernization of our courts is the way to go in this new digital age. It's very important and it affords, apart from many other facets, court modernization improves access to justice insofar as our accountability data would have to be stored into our IT systems, insofar as the pleadings and all other important court documents would have to be accessed from our IT systems. And indeed, there is always a problem of the digital divide because not so many people have access to the IT system. That divide would have to be bridged at a certain point. Because without providing that modernization, which is but one of the facets to access to justice, we're denying people their access to the courts. But regrettably, Minister, some of the tools that would assist us in modernizing our courts, we have to receive them from other, I would say, the Department of Justice itself. As a result, it becomes so difficult to modernize our courts because we are entirely dependent on the resources that we have to receive from the department. As we speak, Minister, we have to use our own facilities as judges in order to get the work done. It becomes difficult in that regard because we have to use our own resources. And I must also say that at present, in our division, there has been a move really insofar as modernization of our court is concerned. The efforts are being made by the department to see to it that the appropriate Wi-Fi system is installed, which will help us to give that efficient and effective service to the people of this country. Thank you, Minister.
Is it the Department of Justice or the Office of the?
The office of the
Chief Justice.
as I understand, the office of the Chief Justice would also have to provide, but certain of the resources we would receive from the department.
Oh, okay.
Right.
So what has been your role? That's what I wanted to understand. What has been your role in this process of modernization, and how will your appointment enhance or help the process?
And Minister, in our engagements, for instance, these are some of the things that we will, the lack of proper IT systems. These are things that we would normally discuss in our meetings, and that we would make the department aware of where we're lacking and request necessary assistance insofar as that is concerned, Minister.
Thank you, CJ, and thank you, Judge.
Thank you, Minister.
Thank you, Minister. Honorable Magwanisha.
Thank you very much, CJ. Good morning, Judge.
Morning, Commissioner.
I have only one question. Generally, it is always viewed that the position of deputizing is a test of character.
It is a
test of character.
right.
There are push-pull pressures. There are people whom you are supervising, but also there is a concept of leading upwards. You are not only leading the people you are supervising, you need also to lead your supervisor, in this case your judge president, ensuring that at all material times there is cohesion, there's good relationships. How would you do that?
It's very important to a leadership position that one should instill collegiality amongst colleagues. That is very fundamental. In fact, in our norms and standards, as a leader, you have to ensure that there are collegial relations between yourself, for one, and your judge president, and between yourself and the other judges of the division and the employees in general. Commissioner, I have got the necessary skill to do that, because Commissioner would have noticed from my CV that I've arbitration and conciliation experiences, should there be a dispute, which I have acquired as far back as during the times when I was a commissioner in various bargaining councils and the CCMA. That skill you use to harness your relationship with your colleagues. You also have to have that inviting and an open door policy with regard to your colleagues. I've got good interpersonal relationship. There's no question about that. And that will be an added advantage to the leadership position that I have applied for. Thank you, Commissioner.
I would have, I would have thought that the judge would have gone at length to explain, because I think the operative word is how. How are you going to ensure that you are leading upwards?
Right. I hear what you're saying, Commissioner. As I said, through my conciliation skills, you invite a colleague if there be an issue, and you discuss with them the problem, and you try to resolve that problem at the earliest opportunity. Because if a problem is not resolved at an earliest opportunity, it may breed or yield into a big problem. So at the earliest opportunity, you try to resolve whatever difference might be, and not only with colleagues, including the employees. And now, and quite often, the employees would come as the deputy judge president. Your office, there's always a knock at your door from employees. There is this particular problem, Judge. Can you please assist us with that? So I will sit with them, discuss the problem in a manner that I will do as I would be sitting in a conciliation problem, ensuring that at the end of the day, there is a win-win situation from both parties and the disputes are resolved. Thank you, Commissioner.
Thank you, Chief Justice.
Just to try and, I don't think Honorable Magwanisha is satisfied. Let me try and help. What if your boss is unreasonable or makes the operation of the institution very difficult? What do you see as your role to bridge the gap between the JP and the rest of the colleagues or the managers? How do you see yourself fulfilling the role of smoothing things on the relationship, particularly when the leader might be having challenges he does not know how to go about? Did I understand you correctly, Honorable Magwanisha?
That's correct, Chief Justice. Thank you very much.
Thank you, sir.
Thank you, Chief Justice, for the clarification. Again, I'm going to have to refer to my conciliation skills. You discuss the matter with your JP. You discuss the matter with the other party, and try to resolve whatever the differences of opinion through open discussions, Commissioner, by both parties, playing that conciliatory role between the parties. Commissioner.
Chief Justice, I will not take
And
it any
in
further.
the event, if I have to carry on, in the event of an impasse, there's always the next level in terms of which you have to resolve your matter. As the Deputy Judge President, obviously, you have to act in terms of according to the norms and standards. They prescribe to us that you performing your functions in terms of the Superior Court Act and any other law as assigned to you by a judge president. In other words, you are in a way a judge president in the absence of the judge president, or as assigned in terms of the law. So in the event of the impasse, there's always reporting the matter to the Chief Justice to see if it can be, if it's a relational problem, if it can be resolved in that way. But you try, you attempt to do your conciliation, reconciling colleagues. Thank you, Commissioner.
Thank you, Chief Justice. I would not take it any further.
Thank you very much, Honorable Magwanisha. Honorable Muiman.
Ke a leboga, Chief Justice. Good morning, Justice Patswane.
Thank you, Honorable Moiman.
The the question that I want to ask you relate to one of the prominent cases that you presided over in the Northern Cape. At what point, within the context of the politically exposed people and the politically connected people, do you draw a line between the right to embark on freedom of economic activity and the right to ensure that the procurement regime processes are respected? The reason why I'm asking this question, it's informed by the fact on the commitment of the party that has sent us to Parliament to fight corruption. And I suspect there's a need to have a clarity of thought in terms of how far as a leader of the executive authority or a member of the executive council or the mayor or a councillor can you go in terms of the canon of restraints that are there, which are outlined within the procurement processes as envisaged by Section 217. The reason why I'm raising this question is because obviously your judgment was affirmed both in the SCA and also the Concord. But what was of interest to me is this point that was raised in the Supreme Court of Appeal. With your indulgence, Chief Justice, let me just paraphrase it. The Supreme Court of Appeal dismissed an appeal in a corruption-related case involving a former member of the Executive Council.
Sorry, Honorable Moima.
Yes,
Sorry, I'm sorry to interrupt you, sir. President Maya indicated yesterday that when we speak softly, she can't hear us. I'm raising a concern just for her benefit.
Thank you, Chief Justice.
Thank you.
Yes,
Thank you very much.
the Supreme Court of Appeal said in doing so, the court mentioned that Mr. B had been a political leader who had achieved a high political office, which he abused to corruptly enrich himself. That the political leaders of this country should set the example and not misuse public office to corruptly obtain personal wealth. And that in these circumstances, it was necessary for an unequivocal message to be sent out there that corruption on the part of politicians holding high offices would not be tolerated. Let me stop there. Can the Justice Patswane respond?
Thank you, Commissioner. Ours as the court is to interpret the law. We look at the facts as placed before us as judges, and we apply the law to those facts. In that case, that was the finding that was made based on the facts that were before court. Commissioner is referring to balancing the interaction. You refer to that. Now, as we all know, that the judicial authority of our country, in terms of the constitution, vests with the courts, and they must act impartially and independently without any fear, favor, or prejudice, in accordance with the oath of office that they took. Insofar as the interaction is concerned, there might be some interaction in this way, in the sense that the organs of the state are required in terms of the law to support the courts by means of legislative and other means. There should always be a delicate balancing of the boundaries between the three arms of government. We will be faced with the facts that are before us, and we have to apply the law as the judiciary. Thank you, Honorable Muimani. Sorry, I hope that I... Muimang.
Justice
My
Fatswane.
apologies.
Thank you.
Muimang.
Thank you, Justice. Thank you, Chief Justice.
Thank you, Honorable Muemang. Honorable Nyambi.
Thank you, CJ. Morning, Judge Patswane.
Morning, Commissioner Nyambi.
I want to take it from where the Premier left it off. We know that Northern Cape is vast, rural, and sparsely populated. So if you can be appointed in this senior position, those things that I've mentioned, sometimes they are impediment to justice. What is it that you can do in terms of the immediate challenges to make sure that the ordinary people in deep rural areas, in that vast province, will have access to justice?
Thank you for the question, Commissioner Nyambi. It is imperative that we should provide access to justice as the courts. How do we do that? At the moment, in the Northern Cape, we've got about 7 circuit courts in Uppington, in Springbok, Colesberg, and the other far-flung areas of the Northern Cape. These circuit courts provides access to justice. We also not only do criminal work in those courts, we also do conduct motion proceedings to ensure access to justice. And not only is the High Court providing this access to justice, we've got the regional courts sitting in these areas. We also have 60 service points that are served by the district courts, including periodical courts providing access to justice. And Commissioner, I will take it even further that in order to provide access to justice, we would have to look at the public defender system, appointing more legal aid practitioners with attractive remuneration, appointing prosecutors to provide this access. I sat in the Provincial Efficiency Enhancement Committee. There was a time when there was a moratorium on the appointment of prosecutors and legal aid practitioners. And in that committee, the issue was resolved at some point. There are legal practitioners from the legal aid and prosecutors that had been appointed. I think it would be shortly before the COVID-19 struck. But not only do we have to, well, perhaps maybe I should even expand more on this, on the practitioners. Which I would call a challenge is some of the practitioners are overbooked. And if we were to appoint more practitioners, that would alleviate the problem and ensure that we give justice to the people. But we also provide access through our case flow management system. We have to give effective, efficient service to our people. It must be remembered, but that through case flow management, the judges control the pace of litigation at an earliest opportunity, avoiding delays. That in itself provide access to justice. And flowing from the minister's question, the court modernization would also assist in providing access to justice. And in some of our district courts, we would have what is called the audio-visual remand system, where matters are being remanded, remotely from the court itself. An accused person will be sitting in prison, and that way we providing access to justice.
I want to ask you the second question. I'll just give you a message that as we are interviewed here today, if I'm not mistaken, it's for the fourth time for the same position. The message is that never give up, because great things take time. Thank you. Thank you, Judge. Thank you, CJ.
Thank you, Honorable Nyambi. Commissioner Tsepe.
Thank you, Chief Justice. Good morning, Judge.
Good morning. Good morning, Commissioner.
Judge, you earlier spoke about the fact that although you have 7 positions in court, there are only 4 permanent judges, so you have to have a lot of acting appointments. What I wanted to ask you is, what systems do you have in place in your division to support acting judges, to equip them in the running of the courts and in judgment writings? And if you don't have, what would you propose were you to be offered the position? Thank you.
All right. Thank you, Commissioner. What we have in the judiciary to assist our aspirant judges to acquire the necessary skills, we would have training that is offered by SAJE, South African Judicial Education Institute, to our aspirant judges, where as judges, to discharge our mandate, we have to participate in the SAJE training courses and train our aspirant judges. As I said earlier, that I have at some point gave judgment tips on judgment writing, sharing my experience and some of the best practices. And fairly recently, I also did so give that training. But it doesn't end there. In the division itself, as a deputy judge president, we always encourage our acting judges that if there is a problem that they can't resolve, you speak to the judge. As colleagues, we have to bounce issues. You have to have that mentoring a skill for the acting judge, and you have to mentor them to become judges of tomorrow. I have done that with our acting judges. Now and then they would come and request some advice here and on some of the issues really that confronts them. That I have done. And you always encourage other senior judges to open their doors as well for the acting judges that are coming into the court for the first time, to expose them to the workings of the court, the judging process itself. Thank you, Commissioner.
Thank you, Judge. Thank you, Chief Justice.
Thank you very much, Commissioner Tsepe. Honorable Singh.
Thank you very much, Chief Justice. Good morning to you and to fellow commissioners and admin team, and good morning, Judge Patswana.
Good morning, Commissioner Singh.
Yeah, I am not going to ask any questions on your suitability because I personally believe you are eminently qualified and suitable to occupy the position that you've applied for. But I am just going to make an assertion and give you my understanding of something, and I may be wrong. And it relates to your participation in community and other organizations. Now, I see you are quite involved in the Solplaiki University. Now, from my knowledge, I know judges and even the Chief Justice was the Chancellor at our very proud university. Our university was very proud of UKZN, but that was more a ceremonial function as a Chancellor. It would seem to me that your function here and responsibilities are more on the operational side. Chairperson of Human Resource Committee, member of Exco of Council. And given the fact that there are universities and even students that are taking matters to court of late, I'm just wondering, do you not see a conflict of interest in your participation in that university in these capacities and your ability to sit as a judge if a matter of university comes before you, from whichever source, whether it's from students or the minister or anybody else? Thank you.
Thank you, Commissioner Singh. I serve in the Council of the University of Solplaiki as the chairperson of the HR committee, in the executive committee, and in the remuneration committee, Commissioner. I see that as a positive for the leadership position that I have applied, because it goes on to show how versatile I am and how I am responsive to the needs of the community of Kimberley. I do not see it as a conflict of interest. And I need to say this again, that I have done a served from the council from 2014, and during my sitting as a council member to this date, I have not received any remuneration from the council of the university, or whether you call it royalties. Instead, what I had said to them is that I am here to impart the knowledge that I have to assist. And it is also important to say that as a council member, you are not necessarily involved in operation. You are much more involved at a governance level. Whatever stipend was due to me as a council member, I've requested them that they give out that money as a donation to the Vice Chancellor's Bursary Fund to assist the people of the Northern Cape. Insofar as there may be matters, it will be one matter from that university that will probably come before our courts for adjudication. And insofar as that is concerned, I cannot, as a judge, act in those matters that involve the University of Solplaiki. You recuse yourself from the onset.
Thank you, Judge.
And for that, Commissioner, I believe that there would not be any conflict of interest emanating there.
Thank you, Honorable Singh.
Follow up, CJ.
Yes, sir. Honorable Malema,
Morning, yes, morning CJ and morning Judge.
Morning, sir. You want to follow up?
Yes.
All right.
Don't
Please follow up,
don't you think it is actually good and in the best interest of the judiciary to participate in positions that are ceremonial than positions that have got some power somehow to take decisions? Because as a judge, if we are to participate in that committee and that committee takes some wrong decisions, you will never take leave from yourself as a judge, even as you serve in that committee. So I think that judges should avoid participating in positions of power outside the judiciary. And that's why when they become chancellors, it's a ceremonial responsibility. It has got nothing to do with you taking any type of position. It's not about you getting money out of it. It's also about decision making. There might be wrong decisions taken by that committee, and when they are taken to the Northern Cape High Court, and that Northern Cape High Court rules against those who are litigating against the institution, or in particular your committee, will still be offended because what are, I agree that chairperson is the judge of that high court. What do you expect? There's no, they will rule in our favor. Because it is what people perceive. It's not necessarily what is factual. So I think you may want to, there may not be a rule that, exclude you from participating in such things. But at times, it's very disturbing to get judges involved in those types of things. You are now going to be DJP by the look of things. I'm not prophesizing, but it looks good. So now, you are going to be a DJP, and then we are going to litigate with Northern Cape University or Prague University in the Northern Cape High Court, where you are the DJP. And at the same time in this university, you are the chairperson of the committee. And when we lose in public rallies, politicians with good languages will say to them, what do you expect? The same DJP is a member, a chairperson of a committee in this university, and then we go to the same court, that's why we lost. And in the eyes of a layman, it looks like indeed it is so, and it damages the image of the judiciary. Thank you, CJ.
Commissioner Malema, justice must not only be done, but must be seen to have been done. I take your point, and yeah, we will take it from there. I did not see it in that way, because one really looks at it as your way of giving back to the community that you are serving. But I take your point.
Honorable Dodovu.
Thank you very much, CJ. Good morning, Justice.
Good morning, Commissioner.
When I was the executive mayor of the city of Matlosana, I interacted with some of the documents where you advise our city about how it must go about resolving the disciplinary matters. And that was quite good. That was at a time when you were still practicing. It was very, very good.
Thank you, Commissioner.
My two questions. The first one, all the legal bodies support your candidature as the Deputy Judge President. But on the other hand, the concerned members of the Kimberley community are raising some criticism about you. They say you are arrogant, you don't listen to them, you are divisive, you also fight with your colleagues, amongst others. How do you reconcile the two? How do you respond to these allegations?
Commissioner, that is very irreconcilable. As you say, those are allegations. They are certainly unsubstantiated. I look at the allegations, I don't see myself as that. All the people, as you said, who gave testimonials in this interviews do not see me in that light. Those are unsubstantiated allegations, Commissioner. Thank you.
Let me link that with what I observed when I was reading the documents of your previous appearance here. A matter between yourself and Judge Pakatu was coming up very strong, and people were, commissioners were raising a lot of issues around that particular matter. What lessons have you learned from that, and how, if you are now going to be in a leadership management position, how can you improve the situation so that there is collegiality, good relationships within the court?
Right. Thank you, Commissioner, for that. As I said earlier, there are collegial relations on Northern Cape Court bench. It's 4 permanent judges at the moment. How do you foster a culture of collegiality? You attend to your colleagues' chambers. You have friendly discussions, either on the law, on issues that are not really or extrajudicial issues. You sit in a tea room together. Sometimes you will bring a cake to the colleagues. In that way, you fostering that culture of collegiality amongst the colleagues. As I said, Commissioner, the allegations as painted, I don't see myself in that. I've got good interpersonal skills, good interpersonal skills, Commissioner, amongst others. And yeah, I will stop there, Commissioner.
Can I make a follow-up? Okay, I see your calmness. I think you're going up there. Thank you very much. Thank you, CJ. A follow-up, CJ Cyril Kleber.
Thank you, Honorable Dodofu. Please proceed, Honorable Kleber.
Thank you very much for the indulgence, CJ. Good morning, Judge.
Good morning.
How are you this morning?
Commissioner? I'm fine, thanks, and you?
I'm good, thank you so much. Just as a follow-up on the question that Commissioner Dodovu raised, there was a perception that you were a blue-eyed girl of the leadership of the division, or rather, let me say, the past leadership of the leadership of the division.
Honorable Kleber, just so that we don't get into trouble, allow me to interrupt you. Maybe you should say a blue-eyed woman.
Oh yes, no, not a perception. Sorry. You are right, CJ. Correction accepted. A blue-eyed woman or a blue-eyed judge. All right. And thank you very much. And how does that make you feel as a judge who has achieved so much, at least from what I can glean from your CV? And what have you learned from this saga, if I may call it that? Thanks.
Commissioner, I don't know. As you say, there was that perception. But I would, and I don't really want to get into too much details about it, except to say that the allegations may have been made that I was dead, but I would dispute that I was dead, because the previous leadership, as you put it, Commissioner, exposed all of us really to the workings of the division. I did not consider myself to be favored. I considered myself to be a judge that was spontaneous, attending to my work and hardworking. And I really don't want to go further into that and to say that that my experience really coming back from practice would show that in itself was a boon. It was an added advantage to how I have done my work. But I certainly, it was a perception, but I don't see myself as that.
I'm satisfied. Thanks, CJ.
Thank you very much, Honorable Klava. Prof.
Thank you, sir. I've been covered. Thanks.
Thank you, Prof. Honorable Breitenbach. Honorable Breitenbach.
Sorry, I'm having trouble unmuting. Thank you, Chief Justice. My question has become moot. It was asked by someone else.
Thank you very much. President.
Thank you, Chief Justice. Good morning, Judge Patswane.
Good morning, President Maya.
My substantive questions have been covered. Just a follow-up question from the possible conflict posited by Commissioner Malema that might arise from your involvement with Sol Plaatje University. If the university were a litigant in your court, would you not consider recusing yourself from those matters?
Indeed.
Just to avoid trouble?
Justice Maya, initially when I responded to the question, I indeed said that one of the issues is one thing that one has to do to avoid conflict of interest is to recuse yourself, or not to recuse yourself, really not to be involved at all in a matter that comes from that university. It doesn't even have to come to the point where you have to recuse yourself. Ordinarily, when that matter comes, you know that you shouldn't handle the matter. Other colleagues should handle the matter.
Yes. I'm sorry, I missed that part of your answer.
Thank you.
Lastly, if you are appointed for this position, which I hope you will you be able to see your current acting stint at the SA to the end and hopefully apply for a permanent position there in the foreseeable future?
Commissioner Maya, come again. Come again?
No, I'm asking if you'd be able to see your acting stint at the SCA to the end if you are appointed now, because we hope to have you for some while yet, for a number of months.
Indeed.
And there's a tail to this question, whether you'd still consider applying for a permanent position at the SCA, nonetheless having chosen this leadership trajectory in the foreseeable future.
It's true. Yes, that's a matter that's not appearing before the or in my CV. Would be that with effect from the 1st of April, as Commissioner Maya says, I am acting as a judge of the Supreme Court of Appeal until the 30th of September, if my memory serves me. Commissioner Maya, only time will tell. But let me put it this way, that I have acted in the LAC, and I acquired a wealth of experience from that court and from my colleagues who I sat with in that court, which I applied in my court. It helps the division acting in other high courts, because when you from those courts, you come with a wealth of experience that you would implement in your division. At this point, I see myself as a judge who's going to the Supreme Court of Appeal, will be acquiring a wealth of experience in that court, will go back to a bench in the Northern Cape and apply that experience that I would have gained from that court. Will I make myself available, Commissioner? President Maya, as I said, only time will tell.
Fair enough, Judge Patswane. Thank you very much.
Follow up, CJ.
Yes, Honorable Malema. Is that you, Honorable Malema?
Sigogo.
None of you.
It's go. CJ.
CJ.
I couldn't make out your voice. Please go ahead.
CJ Lamula also a follow-up.
Oh, you'll come after Commissioner Sigogo, Minister.
Thank you.
Thank you. Good morning, Judge.
Good morning, Commissioner.
Good morning to you. I'm worried. That's why I'm making this follow-up. It may put me at ease that we're not going to come back here and interview you for the ACA in the next sitting of the commission, if we appoint you to this position. Thank you. I said in the coming sitting of the JSC.
The coming sitting of the JSC is in September this year, in October this year, and I will still be acting as the judge of the SCA. My take is that it will be too soon for me to be raising my hand at that stage.
Thank you, CJ.
Thank you, Commissioner Sigogo. Honorable Minister.
Yeah, thank you, CJ. Mine is also a follow-up on the question from the President of the Supreme Court of Appeal and also Honorable Malema with regards to your involvement with the Council of Sol Plaatje. I'm raising this because I know that there's a lot of judges, even the leadership of the Judiciary, who sits in these various councils. Some of them are councillors of the universities because of their standing in society. I've only seen the CJ maybe 2 weeks ago, a week, resigning from the University of KwaZulu-Natal. So I don't want us to send a message out there that it might be something that might arise a conflict of interest. Do you think this kind of giving back to the community and so forth, has it caused problems in the past amongst litigants with universities?
So far, Minister, it hasn't. And as I said, I started in 2014 with that council. At this point, there has never been any issue taken with my involvement at the university. Nor has, for that matter, any matter nor has any matter been referred to me that came from that university to consider as a judge.
Okay, no, thank you.
Thank you, Minister.
Thank you very much, Judge Paswani. You are excused, ma'am.
Chief Justice, I had put my name down, but now that CJ, the issue I want to raise with this candidate, I'll probably raise in the closed session.
Okay, you don't want to give any opportunity to respond to it, sir.
It relates to these questions about whether acting in the SCA means you won't come back here to be interviewed again shortly. I think it's unfair to ask candidates to make undertakings to this body regarding their future prospects in any way. Thank you, Chief Justice.
Okay. I apologize to you, JP, for I see your name is here right at the bottom of my list. Sorry, sir.
I don't require any response from this candidate. I think that issue has been canvassed with her thoroughly. Thank you, Chief Justice.
Thank you very much. Thank you, Judge Patswani. You're excused.
Thank you, Chief Justice. Thank you, Commissioners.
Thank you, Judge.
Justice, the proximity of nomination and the feedback from the law bodies.
Thank you.
Good afternoon, or is it morning or morning? Good morning, Advocate Lever SC.
Good morning, Chief Justice.
How are you, sir?
Very well, thank you, Chief Justice.
Yeah. No, don't look around for me. You won't find me there.
Yes.
I'm in Mafike.
Yes.
Yeah. You have 2 degrees from Rhodes University. Am I right?
That's correct, Chief Justice.
And when? Is there a problem with my connection?
You are fine, CJ.
Can you hear me? Can you hear me, Mr. Lever?
I can hear you, Chief Justice, yes.
Yes. When did you begin your legal career?
In 1988.
Doing what?
I started with pupillage at the Johannesburg Bar, and I passed pupillage that year and commenced practice at the Johannesburg Bar.
And when did you take SOP?
Chief Justice, there is a mistake in my form and my CV, for which I apologize for. It appears there, 2 dates appear, but the 2014 date is the date when I took SOC, and the SOC was actually awarded to me. It was the 19th of September 2014.
And what has been your area of focus?
Chief Justice, at a small bar, it's often difficult to develop a speciality. You have to be a jack of all trades. You have to be able to function in a number of areas. But my function has practically been a bit of administrative law, commercial law, contracts, a bit of delict, and a little bit of family law. And that would summarize mostly of what I've done in my practice, particularly in the last few years.
And how often do you appear in Botswana?
In Botswana, at this point in time, I last appeared there about 18 months ago. And at this point, I don't have anything pending in Botswana at all at this point.
For how many months would you say in total you've had the opportunity to act as a judge of the High Court?
Chief Justice, it's now just over 60 months that I've been acting as a judge in the High Court.
Very briefly, just tell us why you should be one of the 2 to be appointed to the vacancies at the Northern Cape Division of the High Court.
Well, Chief Justice, I think I can make a contribution. I have a certain skill set that I think would be a positive contribution to the Northern Cape. And I do believe that I can make that contribution, Chief Justice.
Yes. Very well, Judge President Kaleti, but before you start, JP, let me have the list of my colleagues who would want to put questions to Advocate Lever. Colleagues?
Matoro Lepu, Chief Justice.
Matonsela.
Schlemmer.
Dodovu.
Nyambe.
Tsepe.
Arnold.
Breitenbach, please.
Thank you. Honorable JP.
Thank you, Chief Justice. Good morning, sir.
Good morning, Judge President.
In your form, you did indicate that there were outstanding judgments then, and I think there were two parted matters that were still to be finalized. Can you perhaps update us in that regard?
Yes, Chief Justice, Judge President, I apologize. All of the judgments that were outstanding when I signed my form have been handed down. The two part-heard matters, one was a civil claim and one was a criminal matter, have both been postponed for various reasons. If I can deal with the civil matter first, that matter was meant to deal with a virtual hearing in the recess in early January this year. But the technical or the IT officer in the Northern Cape was forced to take leave for one or other administrative reason, and I could not ensure that the recording would be properly done, and so the matter had to be postponed further for that reason. The criminal matter is State versus Lashopi. That matter, Chief Justice, had a number of reasons why it was extended. One of them was the prosecutor was exposed to the COVID-19 virus, and so we had to take a number of days off until her tests cleared her. And then shortly thereafter, my secretary was tested positive for COVID as well. And so I had to self-isolate and also until I could be cleared. And then we proceeded with the matter. There were other issues that caused a delay. The two main witnesses who were eyewitnesses had very young children with nobody to look after them. And I thought it was only fair that when the children needed attention, we had to adjourn because they were doing a civic duty, and one needs to be sympathetic and considerate and understanding when these type of interruptions occur. And those are essentially the reasons why those matters have been postponed. And because there are multiple accused with multiple counsel, it's often difficult to get dates where everybody is available. And it was necessary on the last occasion to postpone, to actually ask the intervention of the then acting judge president, because certain of the representatives of the accused had other matters in regional and district courts, and the judge president, the acting judge president, had to negotiate to give us preference, and I asked for permission, and I was granted permission to deal with that matter in the next court recess. And that is a summary of those matters that have, for various reasons, been prolonged.
Thank you, Chief Justice. Thank you, Judge Liba.
Thank you, Judge President. Honorable Premier.
Thank you very much, CJ, and good morning, Acting Judge.
Good morning, Mr. Premier. Good morning.
Let me just try to orientate myself around the question I want to ask. There's an ongoing debate around the South African Constitution, whether it's a liberal or a post-liberal constitution. And I've got my own views that it's a post-liberal constitution because it goes beyond your normal framework and confines of a liberal constitution. You've got a Bill of Rights with socio-economic rights, and you also have powers for judicial review. So I just want to inquire from you, this character of the South African Constitution is post-liberal. What impact does it have on your orientation as a legal practitioner?
Thank you, Premier. That's a very interesting and thought-provoking issue. My view on it is that our Constitution and the writing of the Constitutional Court on this issue I think is illustrated in the political office bearers pension fund versus Van Heerden, where the court dealt with the issue of formal equality or substantive equality, and came firmly down on the side of our constitution hopes to achieve substantive equality, which takes into account that particular categories of persons who have been disadvantaged by history need to have assistance because of that disadvantage. And the only way you can achieve substantial equality is to actually deal with those problems that have been caused by our history. And I think my view is that, Premier, you're quite correct. It's not a purely liberal. I think it is probably better classified as a post-liberal, but I also find limited value in pigeonholing things. I think one has to look at what's required and deal with the substance and try and achieve substantial rights, which means real effect to the rights that are enshrined in our Constitution. Right. I hope that answers your question.
Yeah, no, I think I'm covered. We've established the rule of one question.
Yes.
All right.
Honorable Klepu.
Thank you, CJ, and good morning, Council.
Good morning, Commissioner.
Okay, I do know that the Northern Cape is a young bar. You know, it's actually fairly young.
Yes.
I'm just curious about the numbers so far. Do you have at least,
I haven't counted the numbers and established, but we're a very small bar. It's in the region of 12 or 13 members at this point. There is, I think, one door member, which is the term we refer to. And yes, it is a very small bar.
And you know, I'm looking at your questionnaire. You have a very long acting stint.
Yes.
Which actually says to me you have a lot of experience in training young practitioners.
I have been actively involved in training young practitioners.
I just want you to tell the Commission what are you doing, what you have been doing in transforming and training young practitioners, because if we don't do that, Northern Cape will run short of people to elevate to the judiciary. And how involved are you in training young practitioners, especially women and Black women?
Yes. Thank you, Commissioner. It is a definite issue that all of our members have been trying to deal with. It had been complicated recently by the change to the LPC and the different, at one point the GCB was still appointed as the training agency for advocates. Last year, there was a little bit of uncertainty relating to that. And as a result, we didn't advertise for candidates because we like to do this 2 or 3 months ahead of time, because candidates often have to either resign for work and resign from their current job and cash in pensions and make financial arrangements as well as family arrangements to spend a year under training with no income. So we didn't have an intake for this current year for that very reason. And I'm not sure which way it's going to go now with the bars individually being mandated by the LPC nationally to be training institutions, because as a small bar, we relied quite heavily on support from the bigger bars, because some of the elements of training we're simply not equipped to carry out. And so I think as a small bar, and I'm no longer in the leadership of the bar, there's recently been an election, it's going to be difficult. We'll have to forge relationships with other nearby bars who might have the facilities to do actual advocacy training. And also, the one advantage as a very small bar we had with the GCB, there was always somebody more experienced or with more resources that you could call upon for assistance, particularly if you saw that your candidate pupil had a difficulty in one or other area. There was always someone to call upon. And the rules of the game have now changed, to put it simply. The position we have at present relating to diversity at our bar and training and support of young Black practitioners is we have one female Black advocate at the bar. We recently had one female Black pupil who recently passed her exams, but unfortunately Greener Pastures called. She was offered a lucrative job, and I can well understand that she took it having spent a year without income, and I can understand the other pressing issues from her family that we would need to consider. And we have one Black male member of our bar at this point. I think your question included an element of what am I or what are we doing to transform the bar? It is a challenge, but what I have done as the treasurer is build up a reserve, financial reserve, which the senior members contribute 10 times what the junior members contribute to. And we've used those funds to sponsor one of our members to go to a training course in mediation in Stellenbosch. And we were able to do this by furnishing this member with an interest-free loan, which she has paid back and which will be used again for similar opportunities. But it's not just me that has done this. All of our members of the bar supported it and are looking for similar things where we can support young practitioners to give another skill and another set or potential source of income. One of our other junior members had financial difficulties at another bar, and I counseled this person so that this practitioner could get a clearance certificate from the former bar that the practitioner belonged to. And I motivated for giving that person a second chance at our bar, which I'm glad to say he has taken courageous financial decisions and has been a member of our bar for more than a year. Transformation is a long and slow process, and it needs active involvement and interventions. And we are trying, although I do acknowledge there's a lot further that needs to be traveled along this road, and there's a lot more that needs to be done, but it also cannot be artificially done. It has to be done on a case-by-case basis. And there has been, in my experience, of my colleagues at the bar, a lot of support for this. I hope that answers your question, Commissioner.
Yeah, thank you. But just to follow up, what is the attitude of your bar in training advocates who are not members of your bar?
Well, to be a pupil, you're not a member. You offered the chance to become a member of the bar once you've passed the exam. So we take on any qualified, fit and proper person to who we have the facilities to train, because a small bar, we can't take on 20 pupils. We simply wouldn't have the facilities to train them. We can take on perhaps 2 pupils per intake. And, we would take on the most promising candidates who apply in any particular year, and we would do everything we can to support them in passing the exams. And once they've passed, they would be allowed to join us if that's their wish. In fact, we want them to join us because we're investing a lot of time and effort in getting them ready and prepared to pass those exams. So we really do want, and it's part of our transformation, we want them to pass. and we want members to stay with us. If it's at all possible, we try and arrange, and a wide range of our members have tried to arrange interventions where work is offered to these junior people just starting out. It's very difficult, but and it's hard to generalize, but we are trying to make a difference in that respect.
Thank you, Chief Justice, and thank you.
Chief Justice, I'm sorry, follow up, please.
Yes, sir.
Good morning, Advocate Liver.
Good morning. Good morning. It's my friend, Mr. Mpofu.
Yes.
Yes. Sorry, I can't read at this distance. But
you can pick up my voice.
Yes.
No, thank you. It's been a long time since the good old days at the Joburg Bar.
Yes, indeed.
Thanks. I'm just concerned on this issue. Yes. I represent the GCB here, as you know. Yes. But in reality, I represent advocates for transformation. We have a 50-50 arrangement with the GCB, as you know.
Yes.
Yeah, it's a governance model. So, in my capacity as a leader of the AFT then, we had a serious problem about 4 or 5 years ago where one of our members, I just forget his name, was literally being harassed and racially abused at that bar to the extent that he left. So I'm not surprised when you say you only have one black member.
No, we actually have 2 black members at this point.
Yes, which is also still low. But I'm just saying that one of the reasons is that of those low numbers might be the fact that there was active harassment. I mean, I don't want to go into the stories. Maybe you know the story where the person was not even invited to bar meetings and so on. To the extent that we had to send some of our leadership to go there and meet with the bar and intervene and so on. Firstly, are you aware of that issue? And secondly, if you are, did you yourself play any part in either trying to resolve or that situation, or did you do anything about it if you were aware?
Commissioner Mpofu, I only joined the Northern Cape Bar in 2018. So it would seem that it is 2 or 3 years before I became involved.
You were in the Northwest Bar before that?
I was at the time, and I was chairperson of the Northwest Bar at that time, although I was acting in the Northern Cape during that period as well from time to time. But no, I'm not really aware of the ins and outs of that situation. I do know that there was a difficulty with a certain person, and more than that, I'm not really conversant with the facts.
Just before your time?
Yes.
Okay, thank you. Thank you, CJ.
Thank you, Commissioner Mpofu. Advocate Madon Celeste.
Thank you, Chief Justice. Good morning, Advocate Liver. I'm here.
Sorry. Sorry. Myopia and so on.
I'm the dark one.
Yes.
I'm the black man.
Preamble.
Yes.
Yes. My focus is on in your activities outside of your professional life. It seems from your CV that you say that at some stage you are a member of parliament.
That's
or
correct.
a member of the NCOP representing the Democratic Alliance.
That's correct.
Is that correct?
That's correct.
I just want to find out from you whether you, like my friend on my right, are doubling up as a lawyer and a politician currently.
Mr. Madonsela, Commissioner Madonsela, I apologize. I have not been involved in politics for 17 years now, to the extent that the current representative of the DA on this body I've never met. I have, of course, disclosed that I was a member of the NCOP. And I believe I was privileged to be in Parliament for those 5 years, and I learnt a lot about my fellow South Africans in those 5 years. But I learnt a lot about myself in those 5 years, Commissioner Madonsela. I'm not a politician. I learned that, and I acted on it soon enough, I believe, to save my personal space and my personal sanity. I think I made a correct move in leaving politics, and I'm not trying to cast aspersions on anybody. I'm not saying
looking on my right, but
yes, I'm not saying politicians are bad people. I just acknowledge that I am not a politician. But I don't deny I was there. I don't deny what I did. I appreciated the privilege. I met a lot of people across the political spectrum who I share aspirations with. We cooperate. I like to cooperate with people and find common ground. And on occasions, under certain acts we were considering at the time, which includes PAJA, there were times when I would sit down with the PAC representative and we'd have a discussion and have very different views on almost everything.
So I don't want to waste time on this. I just wanted to.
I hope I've answered your question, Commissioner.
I wish I
Madonsela.
could ask another question on this aspect, but I don't want to exhaust my questions. My second question, unless if she just asks me to ask a follow-up question on the first question. No. Okay, I can move on to the second.
Make your request clear, sir. I'm not too sure what you're asking me for.
No, maybe Malema will do a follow-up question. Maybe I should move to the second one. Because I wanted to ask the question, although you are not a politician, but are you a member of a political party?
No.
You're not.
No, for 17 years I've had no association with
Thank you. The second question, I see that you are also you have stated in your CV that you are Jewish.
That's correct.
I just wanted to find out if you are not a member of the Jewish Board of Deputies.
I was not elected to that body, no.
I don't want to ask a further question. Thank you very much. Others will follow up.
CJ, just a follow-up question on that.
Yes, sir.
The Jewish Board of Deputies, you saying you were never elected into position of power in that body. As a member, were you ever a member of the Jewish Board of Deputies?
I don't believe it works like that. I haven't held myself available to be a member, and I haven't ever been a member. I think the Jewish Board of Deputies is a broad body that represents several different Jewish organizations, including, people in the Jewish faith, or like in any other faith, there are people who interpret it very liberally and some who interpret it very traditionally and very strictly. So as I understand it, and I must say I don't have contact with the body directly, as I understand it, the Jewish Board of Deputies represents all of those bodies and has representatives.
I mean any body that is affiliated to the board.
I'm not a member of any body that's affiliated
thanks.
formally.
Thank you, CJ.
For follow-up, Chief Justice.
Yes, sir.
What is your view on? Good morning.
Good morning. Good morning, Commissioner. I'm sorry I can't see that far to read your name plate, but
I'm also navy blue. Muimang.
Commissioner Moimang, yes.
Yes. What is your view on the two-state solution on the Israel-Palestine conflict?
My personal view
on the two-state solution.
The two-state solution is, I think, the only practicable solution, and I fully support it.
Thank you, Chief Justice.
Thank you, Honorable Moimang. Prof.
Thank you, Chief Justice. Good morning, sir.
Good morning, Commissioner Schmidt.
I would just like to ask of you what your judicial philosophy is.
Commissioner, I believe positivism is firmly in the past. And I see and I view our constitution as being a constitutional democracy that has certain values which are reflected in what I would term natural justice. So I firmly believe in our constitutional values, and I've tried in all my time as both a practitioner and as an acting judge to implement the values of the Constitution. And I think the shortest answer I can give, whilst not cutting it short, is that I am a subscriber to what I understand our Constitution to be, and that is the basis of my political philosophy, my judicial philosophy, and I apologize for the Freudian slip.
Thank you, Chief Justice.
Thank you, Prof. Honorable Dodovu.
Just one straightforward question, CJ. You acted for the first time as a judge in 2007 in the Northwest.
That's correct.
Who recommended your first appointment, and how did you feel like to act for the first time?
Well, at the time, the Chief Justice was the judge president of that division, and so the invitation came from him, and I was humbled by it, and I regard it as a huge privilege to have been invited, and I've tried to give my best from that day forward. I hope I've answered your question.
You acted so many times as a judge.
Yes.
Both in the Northwest and Northern Cape.
Yes.
Is it for the first time you are playing?
No, it's not the first time I've appeared before this body.
All right, thank you very much. Thank you, CJ.
Honorable Nyambi, is there a follow-up question?
Covered, CJ.
Oh, you covered. Thank you, sir. Commissioner Tsepe.
Thank you, Chief Justice. Good morning.
Good morning, Commissioner.
Counsel. Prof asked you a question relating to your judicial philosophy, and in your response, you spoke about your commitment to constitutional values. My first question to you is, in your practice or in some of the cases that you have presided over as an acting judge, could you give examples where you would have implemented the constitutional values, or you have met your obligation in terms of Section 39(2) when interpreting any legislation, or when developing the common law or customary law?
Commissioner Tsepe, one of the cases that comes to mind was covered by the UCT body that researches applicants and their judgments, relates to children's rights. There was an application for me to compel the identity of a person who raised an issue of concern involving two children. And I thought it my duty not to only deal with the facts of the matter before me, but to order that the registrar actually asks that a social welfare worker do a follow-up on the children to establish that the correct sexual boundaries were being observed. And so I believe that is an example in dealing with children's rights, which is something that is very emphatically set out in our Constitution. I hope that answers your question, Commissioner Tsepe.
It does. It does. Thank you. The last question relates to turnaround time relating to production of judgments. In your time as an acting judge, have you had any challenges relating to turnaround time for producing judgments? And if so, what were those challenges, and how do you think they can be resolved? Thank you.
Historically, yes, there were challenges. And there were different underlying reasons for those in each particular case. In one case, I had a litigant filed 2 supplementary sets of heads of argument after reserving the judgment. Well, it's then within the discretion of the presiding judge to either allow it or not, but you have to offer the other litigating parties involved an opportunity to make their representations. And that involves corresponding with people. And once you start corresponding with people, it can be delayed for quite some time. That was one instance. There are challenges, and when there are challenges, I try and make it a practice of mine to approach the judge president of that division and say, I'm experiencing this challenge, and this is how I'm trying to deal with it, and ask for either guidance or input, but at least make certain that the leadership is aware that on this particular matter there is a challenge, and challenges can arise in different and varying circumstances, but in each of these circumstances I try and have an appropriate and considered response.
Thank you, Advocate. Thank you, CJ.
Thank you, Commissioner Tsepe. Commissioner Barnard.
Thank you, Chief Justice. Today, Judge Lever.
Good day.
Yes. I want to summarize my question with 2 words, and then I'll just slightly expand. The 2 words are why you? And then to expand on that, bearing in mind on a very practical level that we have a constitutional imperative as a commission. The question then is, how do we do that? We're faced with 3 candidates in the 2 vacancy posts. What would you say? Why should the commission consider you favorably?
Commissioner Barnard, if I understand, you're referring in essence to the constitutional imperatives that are set out in section 174, subsection 2, that the bench and this body must consider that the bench should broadly reflect the demographics and the gender of our country. So I'm interpreting your question in that light, and my answer as to why me is twofold. Firstly, one should look at the existing bench in the Northern Cape, and while in one sense my candidacy can't be considered to be transformative of the bench nationally, but in the Northern Cape my candidature would certainly give diversity. If I was to receive the approval of this body, it would contribute to diversity. And as I said, when the judge president led me in his questions, I do bring a certain set of skills that I think can make a positive contribution to the bench on the Northern Cape.
Thank you very much. Thank you.
Thank you. Honorable Breitenbach.
Thank you, Chief Justice. Sorry, someone said my guys and my dogs are making a noise.
What's that?
That looks like you. I know you. Glenis, it's you, I know.
They like you, they make a lot of noise. Good morning, Mr. Leader.
Good morning, Commissioner Breitenbach.
I'm the dear member of the commission that you have never met.
Yes, that's correct.
So, and like you, I'm Jewish, and I'm not even mildly ashamed of it. In fact, I'm quite proud of it.
I'm not ashamed at all. I don't deny my religious identity, not at all.
Good for you. So there are thousands of Jews in South Africa, very few who are members of the Jewish Board of Deputies, of course. That's not my question.
Yes.
The question is this: women in the judiciary and in the legal profession in general are held to a different standard, a higher standard, if you will. Have you, in your experience, found that that applies to Jews as well? Thank you.
That's a bit of an unexpected question, and I must say I'm trying to think of an experience. As far as professional work goes, I haven't experienced that. But, prejudice takes many forms, and I'm not sure whether your question is leading to that. But I haven't experienced, I must say, in my professional work or being held to a higher standard because of my religious affiliation.
Thank you. That answers my question. Thank you, sir.
I have a follow-up question, Chief Justice.
Yes, please.
As a Jew, you keep the Sabbath. In the other ways, you don't do any work on a Saturday.
I'm not. Sorry. Please finish your question.
Do you think that will impact your, if you're given, for instance, an agent application on a Sabbath, would you take it on?
I've taken every urgent.
Sorry, I'm asking this question because I'm also Seventh-day Adventist and I keep the Sabbath.
Yes. I must confess that I'm not an observant Jew in the sense that I strictly adhere to keeping the Sabbath. Obviously, we all interpret our religion in our own personal way, but I've taken each and every urgent application that has ever been allocated to me, whether it is at 2 a.m, on a Saturday, or on any of the Jewish high holy days, because that would be my commitment. And I take that seriously. I don't deserve any special treatment. I'm sure Seventh-day Adventist judges and other religious Muslim judges are faced with similar challenges, but you make a commitment, and that's the way I see it. And if an urgent application comes at an inconvenient time, well, so be it. I must just deal with it.
Thank you, Chief Justice. Reasonable accommodation.
Yes.
Thank you, sir. Thank you, Advocate Levi SC. You are excused, sir.
Thank you.
Good day, Commissioners.
Good day, sir.
Good day, Mr. Nxumalo. Chief Justice, the candidate is ready.
Good morning, Mr. Nxumalo.
Good morning, Chief Justice.
How are you, sir?
I'm good enough.
I'm sorry that I was out for a while. Let's talk a bit, just so you can settle in. Why did you do your degrees in Nigeria?
I was in exile, and with the advent of the democratic transition, we received scholarships from the ANC under the Lutuli Memorial Trust in order to undergo various skill training in law, in various countries in Africa because it was cheaper to do so than to deploy and put people through schools in first world countries and so on. So upon the suspension of the armed struggle, more than 500 of us were taken to Egypt, Nigeria, Cameroon, and other various areas where we had to enter the institutions of tertiary education and other educational institutions. In order to do that, we had to write the local joint matriculation exam, board exams of those various countries. And upon meeting the proper cutoff mark, we were able to enter those universities. So it was as a result of those circumstances that I ended up studying in Nigeria, where I acquired my Bachelor's of Laws with an honors. And because I was inquisitive, I decided after my obtaining my LLB, I decided to do the Nigerian bar in order to be exposed as a barrister and a solicitor. I just was fascinated by their system because lawyers in Nigeria are trained both as solicitors and barristers, and they choose how to practice. And what is fascinating as well is that inclusive in their syllabus was the conveyancer. They also become conveyancers and notaries. So for me, the package was quite attractive because it gave me that standing where when I come back to South Africa, I had a choice either to become a solicitor, an attorney, or an advocate. I ended up being an advocate.
And you've been an advocate in South Africa for a while now. And tell us how your experience as an advocate, your acting instinct have all prepared you, including your service in the provincial legislatures. How all this have prepared you for the position you're now applying for?
Chief Justice, my exposure to law gives me an understanding to have a comparative analytical approach towards law. It means I am not just a product of one jurisdiction. And my background then gives me that eclectic view towards the law and to see how best international practices, what are the trends, comparative law, conflict of laws, international public and private law. So I'm quite exposed to that. And my decision to take up a job as a legal advisor, senior legal advisor at the legislature, was informed by being interested in legal drafting and the fact that when I saw the advert, the bulk of it was about interpretation of laws, the drafting of contracts and or statute, policy and other instruments of regulating the environment or the legislative arm of government at the provincial level. So I got a good opportunity. The first mammoth task I had was to amend the Gambling Act, the Northern Cape Gambling Act, in order to bring it in line with the National Gambling Act. And I also had to review the Northern Cape legislature rules because I had other views from a comparative perspective. I would sometimes when I advise members of the legislature, obiter point out what other jurisdictions, what other procedural steps can actually better improve the efficacy and efficiency of that legislative arm of government. My exposure as a senior state law advisor in the Western Cape Public Department of Public of the department, gave me a more exposure to procurement, because as the Chief Justice would know, the Department of Public Works is one of the major departments in the executive which owns property, transfers property, builds roads, has to build clinics, and it's a very critical arm of government as far as procurement of services and the rendering of services is concerned. So I learned a lot of procurement law, public finance management law. I could make inputs to make sure that BACs and DACs in the procurement process are compliant not only with the Constitution, but with the Public Finance Management Act and other prescriptive legislation. My experience at the bar, it's generally as a legal practitioner and arbitrator, and what is important, and perhaps I should cut to the chase, is the singular opportunity I received from the JP of the Northern Cape inviting me to come and act in the Northern Cape around this time last year. It was singular because I am from the Northern Cape originally. I was born and bred in Khalishiwe. I have a very passionate link with the province. And to me, it was an opportunity to come back now, almost 14 years later, after applying my skills elsewhere, to come and really give back to my community and my indigenous province. And perhaps I should just say, the development that I was exposed to as far as the allocation of matters was concerned was all rounded. I was exposed to criminal appeals, criminal review applications from the magistracy. I had an opportunity to sit as part of a full bench and as part of a full court. I was also given the opportunity to write some of the judgments which came out of that court. And I was really, how should I put it modestly? I was flattered that I was given that opportunity and thrown in such a deep end without anybody having said, can I see how you can string together some few sentences before I embarrass this division? And for me, I had to pull all the stops and ensure that I punch at the level which a jurist is expected at the High Court, regarding be there that any decision of the High Court is susceptible to being appealed by a disgruntled or an unhappy party. I enjoy civil law. Civil work is generally my forte. It's commercial tax and sometimes here and there land issues. But I've been involved as an arbitrator, and if the judge has regard to my CV, Chief Justice will observe that I went on to do a postgraduate qualification in legislative drafting. So I'm a bit finicky about drafting, and I just enjoy it as a way of clarifying and expressing your views, your interpretation of the law in a clear way, in an eloquent way, in a succinct way, and stating the law as simple as you can, but still without compromising the quality of your judicial interpretation of the law. So to me, it made me conscious that I'm writing and I'm adjudicating for people who should understand and have access to justice. And just before I came in, I was flattered by one of the candidates that with whom I am competing for this nomination with. She brought to my attention that a decision I penned down in the Caltex oil against some other party, which I penned down and was taken on appeal, has been the Supreme Court of Appeal has confirmed my decision. So to me, that is very, very reassuring, and it tells at least whoever is my pundit that if at least the Supreme Court can agree with one of my matters in the commercial field, I should be knowing what I'm doing. And they have made very positive remarks about the quality of my judgment, Professor. There am I, Chief Justice.
Thank you, Mr. Numalo. Just one question unrelated to your suitability, or maybe related. Just if you could give me a quick answer to this one.
Yes.
Given your experience in drafting legislation, what advice would you give regarding the concern some of us have about the quality of drafting in relation to legislation that we occasionally come across, concerning quality of drafting? I don't know if you've picked it up, but some legislations do raise serious concerns regarding the quality. You don't know what is being said. What advice, if any, would you give in this regard?
In my
what is the problem? How could it be solved?
I think it is all about how you employ your words and what your brief is all about when you're drafting legislation. Because as a drafting person, you should be a wordsmith. You should be able to avoid ambiguity, pursue clarity, and avoid verbosity. Because the more you bring in a forest of words, the more you now create a desert of facts. So the important thing is to ensure that you are precise, you are accurate, you are concise, and each section or subsection must contain one proposition. You shouldn't overload certain legal propositions all in one section. There is the logic of subsectioning, because it must carry one clear provision to say people must not walk on the grass, and it must stop there, and then you must give other, shouldn't be on the grass and they must, and then it becomes convoluted, vague, and embarrassing, I suppose. So we need to have more drafting skills that are clearer. I prefer the Australian drafting method, you know, which bullets down points in a manner that you are able to mathematically say, in order for me to prove this, there must be A, B, C, D. It doesn't conflate matters in such a way that a reader will have to discern what he or she has to meet in order to be able to invoke whatever section is the subject matter of interpretation.
Thank you very much, Mr. Numa. Colleagues, may I just take down the names of those who want to put questions to Mr. Numalo?
Malema.
Muimang.
Lamola.
Mpofu.
Tsepe CJ.
Schlemmer.
Matolo Lepu, Shide.
Arnold.
Honorable JP.
Thank you, Chief Justice, and good day, Advocating Numalo.
Good day, JP.
It's not about bow ties. Eh?
That's fine, that's okay.
Yes. Sorry for the preamble. Just two issues quickly. I couldn't find any certificate of good standing from the Legal Practice Council attached to your papers. That is the one thing. And secondly, there is a matter which was reported in the All South African Law Reports in 2001, which is in Ngumalo versus Northern Cape Society of Advocates. I believe if you are the applicant in that matter, you made an application for admission in the Northern Cape. There was an issue relating to certification of your foreign qualifications, which was a requirement in terms of legislation. On the facts of the matter, it appeared that you drafted your own papers and you moved your application, and the society took or opposed the application, and your application was dismissed for want of that certification and the manner in which the documents were presented. But subsequent to that, it appeared that you admitted in the Western Cape. Can you perhaps shed some light as to whether you ultimately obtained the certification or your view remained that it was not necessary? And what happened to the proceedings in the Northern Cape? Did you pursue them further by appeal or?
No, I didn't pursue it further by appeal because it wasn't res judicata. What I understood is correctly pointed out, it was a Rule 63 issue of the certification of foreign obtained certificates. And when I approached members of the Northern Cape Society of Advocates to assist me in, as it is collegial, it's a pro amico application that you would approach legal practitioners to assist you to join the profession. It was not cordial and I could not get any assistance from that society. So I was left on my own and I felt affronted that this was a fundamental right because this is my right and freedom of profession, which is embedded in Section 23 of the Constitution. And that if it will be frustrated over technicalities, my novel argument was to say there is nothing in the papers which, one thing I must concede is that the Section 63 issue was important. But you and I, JP, know that in terms of Section 27 of the Uniform Rules, a court can condone non-compliance with the rules. So no rule is sacrosanct within the two hardcovers of the Uniform Rules. And my argument was simple to say, it's either I am a qualified lawyer or I am not. Do you accept the bona fides thereof? And it can be condoned. And there was a general negative reaction that I received. And I went to tick the boxes. And at that time, I was already traveling between Cape Town and the Northern Cape, advising the NCOP when it goes to Cape Town to vote on Section, is it Section 75 bills where provinces should, is 76. Yes, thank you. So I was already situated in Cape Town and situated in the Northern Cape at the same time. So I approached members of the Western Cape Bar and they assisted me and conduced my admission. I hope I have answered. Yep. The issue of the LPC, I could have misconstrued the clearance letter from a professional body. And I advanced a certificate from the Johannesburg Society of Advocates. And perhaps I should have added in addition thereto the LPC certificate of good standing. But you can take it from me as an officer of this of court. I am in good standing with the LPC.
Yes. No, there are two certificates from the Advocates Society for Advocates. But if I understand you on the first issue, you say you were admitted without the need for certification, it was condoned. Of the
No,
foreign
it was
country.
not condoned. I then had to go to the embassy, the Nigerian embassy in I think here in Joburg, and obtained a certification in terms of 63. I also went to the South African University in order to meet the requirements of Section 3 of the admission of Section 3 subsections elsewhere, where it says your foreign qualifications must be certified by a university in the Republic, that your degree is either a superior degree to that offered by that university or is equivalent. So the university did issue that certification, and that opened the way for my unopposed application.
I see.
For admission.
And then the second issue, with the permission of the Chief Justice, there was, when you were acting in the Northern Cape, a complaint that was lodged against you regarding your late coming to court and the allegations that you appeared to be short-tempered to an unrepresented party, and that you threatened the party with contempt of court sanction. And it was referred to me. I dealt with the complaint and couldn't find merit on those, save for your late arrival at court on that day. And I did discuss with you that you should not do that. And I take it that there's a lesson that we must have learned from that. And as far as I'm aware, there are no pending appeal proceedings against that complaint or ruling that I made.
Not to my knowledge, JP.
Yes. Okay. During your stint, that was during COVID lockdown, when it had just started. Would you say you covered sufficient ground to prepare you for permanent appointment?
Well, it's, for me, I think if one has regard to the areas of the law I covered in those two terms, I think I have sufficient exposure as to how that court runs and the nature on matters that come before that court. I've ably been able to adjudicate them in urgent court, reviews, automatic reviews, appeals, criminal law appeals, motion proceedings, both opposed and unopposed. So I think I do have enough, especially regard being head to my 14 years of practice as an advocate in one of the biggest divisions in the country, and having held my own for 14 years and building a decent practice as I have done. I think I am more than capable of being able to take a permanent position at this stage. 6 months, I mean, roughly 2 terms, relatively might be looked at askance as a way of determining whether I'm qualified or not.
On the criminal matters, how many criminal matters, according to your recollection, you did?
A rough recollection.
Trials, sorry, criminal trials.
I haven't had an exposure to criminal trial because of the COVID conditions. We dealt mostly with appeals and reviews from the magistrate, from the magistracy.
I see. Thank you, Chief Justice. Thank you, Advocate Ngumalo.
Thank you, Judge President.
Thank you, JP. Honorable Premier.
Thank you very much, Chief Justice. And I think I'm the first to say good afternoon today to you.
Good day,
Ngumalo,
Premier.
Because it's just a few minutes after midday.
Good day,
And,
all the same.
Let me, you've basically responded to the first question which I had. And the second one is to prompt you to think about something, your views on the impact of the constitutional, on the impact of the transformational spirit of the Constitution in addressing the vast socio-economic challenges in the country and as well as in the province?
For me, Premier, we should first understand our constitutional, transformative constitutionalism. It is, you'll find it embedded in the preamble. We must recognize the disadvantages of the past. So once we put the debate in that paradigm, everything we do should become transformational, should become reformative, and it should become equitable. So you cannot have equality without equity or equity without equality. So the whole concept of constitutional transformism for me is all about linking the morality of the law and the morality, the ethical and Ubuntu with the law as it stands from the positivist school of thought. The positive school of thought says the law is the law, just apply it mechanically, regardless of the consequences thereof. Your transformative constitutionalism says, but why don't we look at what is the purpose of the law? And if that purpose is not achieved, then that law is not effective. So we must be very busy trying to look as to how can we interpret the law in a transformative constitutionalist perspective.
Just have a follow-up question, CJ. Maybe in your stint as an acting judge, can you give us an example where that was applied practically?
I might not have really had a quintessential opportunity as such. But what I can say is that my judgment and my judicial reasoning is permeated by this transformative constitutionalism. I first test any legal proposition against the Constitution. Nothing is sacrosanct to me. So if it flies in the face of the Constitution, it doesn't pass muster. So you'll find, and perhaps I could have said it more clearer in the Caltex case, because the freedom of contract was one of the issues there, because the other party wanted to interdict the other one to remain in a contract which the other party contended is no more in existence due to effluxion of time, and it has lapsed. And the party contending to resile out of the contract says, should I be interdicted to remain in this contract, which I claim does not exist, is going to affect my freedom of association. I do not want to be associated in this business with this party anymore. So that for me was clear. And when it then informed in an unarticulated paradigm that he is right. Should this interim interdict be given and the final interdict is not granted, I would have violated his rights to freedom of association.
Just on a lighter note, it could be on a lighter note. You actually raised the issue, very interestingly, the issue that nothing is sacrosanct. Is the Constitution not sacrosanct?
Well, sacrosanct, if one were to say it's untouchable or it cannot be tinkered with, or sacrosanct in a way that it remains the supreme law of the country, such that Section 2 proposes that any act or law which is inconsistent with it is null and void ab initio. So I would say, if one looks at it from the perspective of the supremacy of the Constitution, and the fact that everything that the Constitution requires to be done must be done speedily and without delay, as required by the Constitution, it gets that status of being sacrosanct. To the extent that it must be amended by a particular percentage of majority also lends into that proposition. It's not your ordinary legislation. That is why it was very shocking to some of us when it was called an act, that it was Act 108 of, or is it 106 of 1996. We were like, wow, is this constitution really an act? It can't be, because it doesn't share the same status with other legislation. It has entrenched powers. It trounces any law which is inconsistent with it.
Thank you very much for the eloquence. Thanks. Yeah. Thanks, Advocate.
Thank you. Thank you, Premier.
Follow-up, Chief Justice, and then I forgo my place in the line.
Please go ahead, Honorable Manu.
Thank you, Chief Justice. Good afternoon, Mr. Numalo.
Good afternoon, sir. Yes, I am sidelined by the TV here.
Yes.
Yes.
Look, I think from your articulation of your understanding of transformative constitutionalism, I guess as a practitioner, you must have made a reflection in the application of our courts of this constitution in the last, let's say, 15 to 20 years. And among the issues that emerges is that the application of our courts of our constitution to a certain extent is informed by a normative constitutional theory, which mainly is divided into two: the critical legal theorist and also the liberal legalist. And these two camps, they use certain criteria, both the Dawkinian and legal positives, as you have indicated. And that at the ultimate, what informs the reception of the public in terms of the outcome of the judge is to what extent the court surpasses the level of tolerance in terms of this framework. If the public is of the view that the court went beyond what is expected in terms of ensuring that the judgment is informed by the moral content, they will rebel. But if they are of the view that it acted within the moral component, like as you have correctly pointed out, they will celebrate. What is your view on that? Thank you.
Commissioner, and that's very deep jurisprudential debates, but I'll cover them from this angle. The Constitution is our public policy. So whatever permutations we have as jurists, all of them must bow at the altar of the Constitution. It has its own jurisprudence. So whenever you read the Constitution, it must be purposive. What do you want to achieve, and what does the Constitution want to achieve? So you can come being liberal, or you can come being positivist. The Constitution will make you to fly right, because you are not going to interpret it in order to defeat its very purpose. So I find it to be a nicety for us today to come and say, I'm a naturalist, I am this or that. I would take a very pragmatic approach as Oliver Wendell Holmes, who belongs to the realist school. His proposition is that forget all these theories. What is important is how the court pronounces and what it says the law is, having been held to the common law, statute, and the Constitution. So he also says, over and above that, the law might either be found to be limping behind the society, or the society might be limping behind the law. So there must sometimes be a sense of compromises. There will be some tension. Sometimes the courts might be ahead in the thinking of the society, and sometimes the court must have to come to speed. He speaks of inarticulated paradigms that judges bring into their judgments to say, if I'm black, I'm disabled, or I'm a woman, or I am of a different cultural hue or cry. I would bring those things without having said them, but they will be there between the lines of my judgment. But the paradigm is a constitution.
Thank you, Advocate Nimalo. Thank you, Chief Justice.
Thank you, Mr. Commissioner.
Thank you, Honorable Mwemang. Honorable Malema.
Thank you, CJ. Thank you, Advocate. Do you know Godrich Gadi?
Oh yes, Mr. Malema. We were in exile together. I think he went to Yaba Technical College in Lagos, and I think he's a former General Secretary of EFF.
Yes.
I'm very proud of him. I've seen his progress over the years.
So he tells me that when they went to learn all types of disciplines in Nigeria,
yes,
you went to learn law, and you were almost the only one because it was not fashionable to learn law in Nigeria, especially from amongst your peers
yes,
from the camps.
Oh yes, Mr. Malema. It wasn't attractive because it's a long program. In Nigeria, an LLB honors is 5 years. And we were at the cusp of our democracy, and people were nostalgic and tired and things like that. So people picked very short courses in order to just get some upskilling, because we were not so much as given a choice. We were told to go to school. It was just a pension that, listen, not all of you are going to be soldiers in a post-apartheid South Africa. Some of you will have to become mechanical engineers, will have to become lawyers and doctors. So we're not going to have an inflated military or just to accommodate everybody. So we heeded that call, as disciplined as we were. And I looked at this program, I said, well, I will make it. I am 50 now, but I was young then, and I thought, this is an opportunity, given my historical background. I will not have this, I don't think my parents would have sent me to school to study law. That time there was no NEFSAS and other things. So I just said, let me take it with both hands and utilize it completely.
Are you still a member of any political party?
Not at all. I've deliberately decided to disassociate myself from politics and terminated my membership of the ANC as long back as when I actually joined the bar coming from Cape Town, when I left Kimberley and to become a state law advisor in 2004 in Cape Town. That is the time my membership, I submitted my resignation. I explained my decision because I had decided to become a jurist.
Will your appointment to the bench usher in a new generation and with people of different mind and people who studied outside the South African universities, which most of them were at that time biased?
Oh yes, Mr. Malema. I can assure you that, I am, what can I say? My intellectual and jurisprudential overview is decolonized. I'm not a product, and with due respect, I am a product of Black professors, Africans, and I could see the capacity and the capability of what we are capable of doing as Black people, given the equitable conditions that any society should get. It's very difficult to discriminate against people when they are the same. In Nigeria, there's nobody who can tell you that a Black person can't read tax law, a Black person can't do maritime law, because you'll have to import white people to come and do that in Nigeria, because the only lawyers you'll find are Black. So you don't have this kindergarten schemish about racism. You actually, either you know the law or you don't. You don't segregate it based on racial complexions. You determine whether a person is capable to, in a particular area of the law or not.
Thank you, Advocate. Thank you, CJ.
Thank you, Mr. Malema.
Thank you, Honorable Malema. Honorable Maganisha.
Thank you very much, CJ, and good afternoon, Advocate Numalo.
Good afternoon, Mr. Commissioner.
No, thank you very much. In light of the Legal Practice Act of 2014, I am also interested in this issue of foreign qualifications. Did you experience any glitches when you came back to South Africa in terms of now you were trained in Nigeria to understand the application in South Africa? Did you experience any problems being a foreign trained lawyer?
Not so much to write home about, because both countries have British colonial background. They are former British colonies, and they have brought English law is also about what colonial countries received from Britain and applied subject to the necessary modifications in South Africa. All I had to do was to deal with the nomenclature and the difference of certain terminologies in the different disciplines. For instance, in English law, you would refer to delict as tort. You would refer to an injunction instead of an interdict. What I found really quite interesting, and I think it's something I would want to debate on other forums, is how common is common law in South Africa? When in other jurisdictions, that so-called common law is called received law. And it only becomes law when it is interpreted by a court in the country and is applied mutatis mutandis. You would also have to question how do we begin to aggressively develop customary law to a point where it must congeal into common law and stop having this dichotomy of saying this is common law, this is how it must be proved, this is customary law, then it must be proved as if it's evidence. So there is space for transformative constitutionalism, Premier.
You direct that response to me now. And you do that at your own risk.
Chief Justice, just one issue. It's less than a second.
Proceed, Honorable Maganisha.
Thank you very much, Chief Justice. Except acting in the Northern Cape, have you acted anywhere else?
No, I haven't acted anywhere else. I have, no, that's a short answer. I haven't acted anywhere else. This was my maiden acting.
Thank you very much, Chief Justice. Thank you, Advocate Numalo.
I thank you.
Chief Justice,
Chief
I just
Justice.
have a small follow-up, if it's possible.
Yes, sir.
Good afternoon, Advocate Nxumalo.
Good day, Judge.
Should I say Ndwandwe?
Zwelekalanga.
Mkhatshwa. Since you ventured into that subject, I just wanted to check. You mentioned that you questioned the existence of so-called common law and other streams of law. But since we have a constitution that is the supreme law of the land, don't everything else develop constitutionally?
Oh, yes.
So we're creating just one law.
Oh, yes, Judge. You are correct.
Okay.
And that is why you'll find in Bakazane, these matters have been settled to say our public policy, anything, there is no proposition in our law which must stand if it does not pass constitutional scrutiny.
Okay, thank you. The issue that forces me to respond is you say you've never acted anywhere else. I'm jealous when people in Gauteng look for greener pastures elsewhere. You belong to which bar again in Johannesburg?
The Johannesburg Society of Advocates,
Yeah, but which group?
BJ Chambers. I'm
Right.
a founding member of BJ Chambers.
I know that my office sends out letters to all the groups requesting people to avail themselves for acting stints. Have you ever seen that?
Oh, yes, Judge, I did.
Thank you very much. Thank you, Chije.
Thank you.
Chief Justice.
Thank you, Judge President. Honorable Minister.
Chief Justice, a follow-up.
Okay, all right. Yeah, go ahead, Commissioner Sigogo.
Thank you. In the Nigerian system, there are special customary law courts, like the customary appeal court.
Yes.
Do you think that system enhances the development of their customary law? And if it does, do you think it is thinkable that our legislature should think of the same?
I would quite frankly criticize the fact that such obvious institutions from a Pan-Africanic perspective have turned into some big, insoluble or intractable problems. I mean, Africans must have African customary law courts. Where else would they adjudicate customary disputes? It's like asking a Chinese whether there is Chinese courts. He would laugh you out of this place. It's so un-African that we should be debating things that are supposed to be commonsensical as to whether Africans need customary courts. It's like a fish that needs water.
Thank you. Thank you, CJ.
Thank you so much, Commissioner Sigogo. Honorable Minister.
Thank you, CJ. And good afternoon, Mr. Ngumalo.
Good day, Minister.
Yeah, I just want to start where you ended. Do you think the traditional courts bill before Parliament now will respond to what you have just said with regards to the customary courts as they exist in Nigeria?
It does. I think the naughty point about the traditional courts bill today is about the opting out and the non-opting out, whether or not people who are ordinarily fall automatically within the jurisdiction of customary courts have a right to opt out. But as matters stand, we can debate for a long time in the abstract when we do not have the courts on the ground and begin to develop that customary law jurisprudence to determine these issues which now we are debating at an abstract level. So the principle must be, yes, these courts must come into place, and we are going to begin to debate how they must operate and there would be jurisprudence that will develop therefrom if a person is subjected. That is how jurisprudence develop, Minister. We didn't wake up in the morning and know what is Plascon-Evans test. Somebody took it to court and promulgated a proposition which was endorsed by a judge. So every theory of the law must always be tested before we can determine whether it's right or wrong. Otherwise, to debate it in its absence is like debating how many angels can dance on the head of a pin.
You have been a state law legal advisor even for the provincial legislature. What do you think your appointment will help in terms of enhancing the understanding when courts are faced with some of the decisions of the executive or any arm of the state? Because sometimes there are issues where you realize that there could be issues of practicality. So how do you think that experience of yours will help enhance the bench in understanding some of the things that the state goes through as it deals with most of the, or to make decisions on policy or legislation?
I should think, if I were to canvass for myself, is to say I have worked in the legislative arm of government to the extent that it is a provincial arm. I've worked in the executive arm of government to the extent that I worked in the department in Cape Town. And the fact that I now bring in the judicial arm of government, I am very suitable in order to be able to have a 3D view of what the legislature, how it makes its laws, how they are supposed to be executed, and how they ought to be interpreted by our courts. There are some lawyers who are not as fortunate to have, they may have just developed in one arm of government, either from practice right into the judiciary. They don't understand. Some of them, if you ask them about certain post-apartheid legislation, they don't know what you're talking about because they were not schooled in that and they don't practice that. So as a legal advisor, I saw myself having to teach practicing lawyers what the legislature's laws are and what regulates it, and practicing lawyers sometimes to advise them what the department, what are the imperatives of the department and the regulatory framework. And then they come back to me with an invoice and I'm like, but this is too much for somebody who didn't understand the concept from the beginning. And I guess that's why I joined the bar.
With your indulgence, CJ.
Honorable Minister.
Yeah, I have one last question, Mr. Nxumalo. We are faced with one of the candidates, yourself. You are a former member of the ANC. There's another candidate who's a former member of the Democratic Alliance. Do you think this should be given weight when we consider both of you?
Not at all, not at all. We are not campaigning for any political party, and we are not standing for any position here. I think what should be tested is whether our appointment would achieve the imperatives contemplated in Section 174 as to how the demographic outlook of the provincial division of the High Court would look like, how representative it would be regarding head to national demographics as well as the provincial demographics. And over and above, it should not be that, no, because he is an African black male, he should not be able to ascend to the bench because there are too many Africans in that bench or vice versa. But it should be a balancing act from the judiciary, from this commission to achieve the purpose contemplated in the section I referred to.
Thank you, CJ.
Thank you, Minister. Advocate Mpofu.
Thank you, CJ. Good afternoon, Advocate Nxumalo.
Good day, Advocate Mpofu.
Yes. CJ, I have to declare that my wife is a Nxumalo. So if I ask this candidate wrong questions, it might cost me a lot of kettle.
No, he must excuse himself.
Yeah. Yeah, no, definitely. And what is worse is that she's also Makabani Gatambo, like you. Advocate Nxumalo, I know you quite a lot. You and I have served in the Bar Council. We were representatives of Advocates for Transformation in the Joburg Bar Council and so on. And you've been nominated, among others, by people that one can call some of the top veterans of Advocates for Transformation. Advocate Ish Semenya, SC, Anthea Platt, SC. To what extent would your experiences, I'm also anointing you as a veteran of AFT, influence your approach to issues of transformation of the profession, broadly speaking, the profession not being just, practicing lawyers, but the profession, including the judiciary, access to justice, all those issues that you know all about. To what extent will that grounding that you'd have had from an organization such as AFT influence your approach, particularly to issues such as the perennial problem of briefing patterns and so on? Looking at it now from the position of the bench.
I should say, dear Commissioner, that the briefing pattern or the transformation thereof has got to come with an ability to ensure that people are properly skilled. You would know that the mantra of Peter Chambers is that it's a transformation initiative. And we understood, and Ishmael tends to put it better, he says, we understand that we are practicing in an environment where black is blithe and white is bright, or that proposition, that fallacy is perpetrated in the way that the briefing pattern lies out. So it is important for us to skill ourselves, to develop ourselves as historically disadvantaged people and actually beat anybody that comes to join you in the game, not just to win, but to win hands down. To me, that will give confidence to those pundits that do not want to brief blacks because they think they are blithe. That fallacy will just go away. It will, and it is about skilling us up. Now, from a judicial position, of course, I become an armchair revolutionary. I can only ensure that with the bar, I participate in advocacy skills training, because you can't train an advocate to become an advocate without putting even the content of the subject matter of the law in order for that person to be able to interpret such laws. So it's skills, and is change. And as a judicial officer, there should be a line where you say, I cannot be overactive in certain issues, lest it be perceived that those that are perceived not to be transformed might not appear to be treated fairly in your court. I hope I've tried to put it in a...
Yes, no, thanks. I'm satisfied with that. The next question I have is, you mentioned section 1742, which is of course part of our constitution. And I'd like you to comment on this. My take is that that section wanted to address a particular reality in 1994, 1996. And that maybe it is deficient, that section, insofar as it only highlights issues of race and gender, important as those issues are in our context, as you know. You've mentioned, for example, and my take is that we need diversity, because that 1742 is a diversity provision. But that diversity should not be limited to race and gender. It should also include diversity of class, the ideological diversity in particular, which is what my question to you is all about. You've spoken about Pan-Africanism, for example. Now, a narrow interpretation of 1742 would say you're a woman, therefore you are advancing feminism, or you are going to be a soldier against gender discrimination, which may not be the case. You may be a woman, but would be one of the most conservative people in terms of gender dynamics. You may be black, and you may also think that whites are superior. I mean, Mangopes and all those people were black, had a black skin. Yeah. So transformation should be taken to another level And my question related deals with Africanism. To what extent would you say, for example, an ideology like Africanism should be sold into the judiciary as one of many contesting ideologies? There might be people, for example, who believe, like me, that Africa is one continent and we should approach things like that. There might be others who say, no, once you cross the border of Lesotho, then it's another place completely. That's fine. Both ideologically, there's no right or wrong. But the point I'm making is that to what extent should we have diversity of thinking rather than just pigmentation or gender, which are, both of which are also important?
The judiciary only stands to benefit from the diversification of views that it comes into. If you are in a diverse group, as you would know, you would have various inputs and influences in the way you look at the law. And I then say, should the judiciary show that the demographics, and you and I know that demographics is not just about color and gender. Demographics can cut, depending where you look at it from. You can look at it from income and to determine how does the demographics play themselves out. You can look at the level of education and so forth and so on. So it is not too difficult to understand that you need all kinds of people from different walks of life in order to give us what we should now call South African common law.
Thank you, Mr. Chair.
Thank you, Advocate Mpofu. Commissioner Tsepe.
Thank you, CJ. Good day, Advocate.
Good day, Commissioner.
I have two questions, and they are related to some of the answers you've given. The one relates to your other adjudicative experience over and above your acting stints at the Northern Cape High Court. In your application, I think it's paginated, page 31, you note that you are an arbitrator under the auspices of the Arbitration Foundation of Southern Africa. I just wanted to find out if you have actually had arbitration experience, and in your mind, you think it would be other adjudicative experience that you think would stand you in good stead or be relevant in your role as a judge were you to be appointed. Yeah, that's my first question.
Yes, ma'am.
Oh, excuse me, or any other adjudicative. I'm picking that one up. Any other?
The exercise of adjudicating might differ procedurally from one fora to the other, but it's all about interpreting facts, applying the law to the facts, putting them clearly, succinctly, so that your reader is able to understand how you got there. So it requires a lot of writing, research, and reading. And for me, those are the components that would build a good jurist. The law is in the library. So if you don't know where the library is located, you cannot practice as an effective or an efficient jurist in any capacity. What I have done as an arbitrator, both in the arbitration proceedings, I've been able to write awards, applying actually, there's a very discrete difference between arbitration and civil proceedings. It's just that one of the prominent elements is that it's a private legal proceeding which is not published and or people have access to in order to check its jurisprudence. But it's also the shortest way and the quickest way of resolving legal disputes without destroying future relationships of the parties. So to me, I think any arbitrator becomes exposed when such an arbitration is taken to court to be made an order of court. And the Arbitration Act does contemplate provisions where one of the grounds of review is when an arbitrator has conducted himself irregularly. So the arbitrator is wearing the same cloak as a judge because there is case law that says he is performing judicial functions. His decisions are not administrative in nature. So call it quasi-judicial powers, so forth and so on. But arbitration puts you in the cold front as you would sit as an arbitrator in a court which is open to the public and is regulated by the Supreme Court, the legislation and other procedural rules.
Thank you, Counsel. My last question, in your application, where you asked to talk of outstanding judgments, there is a judgment of Smith versus State, which was reserved on the 4th of September. I just wanted to find out whether you were the scribe on that matter and whether the judgment has already been granted, and whether, while acting, what was your turnaround time in relation to judgments? Were there any challenges on matters allocated to you with regard to turnaround time, and how do you think, if there were, those challenges could be dealt with?
I do not have any outstanding judgment as we speak. The matter of Smith against the state, we decided that since I had hinted to my able leader, Patswani, that this record is in Afrikaans, I would like us to write this judgment as a court, because as much as I am conversant in Afrikaans, I would not become adventuristic to think that I can write or understand legal concepts in Afrikaans. I have considered that I am foreign trained. So I said, my sister, I'm getting into very uncharted waters, but can you hold my hand? Let us write this judgment together. So my stint came to an end. I had to come to Johannesburg and pick up my practice where I left it. And of course, she has got her own commitments as a judge. So our drafts and drafting process had to go to and fro, but in a nutshell, the chronology of this matter is as follows. It was heard on the 14th of September 2020. We then decided to ask for further submissions on the 9th and the 21st of March, and we delivered it on our judgment on the 31st March 2021. We decided to ask for further submissions this year because we thought, why remit the matter back to the magistrate to go and redo the sentencing when actually all the facts are before us? So we then invited parties to make submissions as far as sentencing if we find that there was a duplication of the charges of rape against the accused, because it was going to affect the totality of it, but it is in bed now.
And you don't have any challenges?
Not at all. If you look at the chronology of my judgments, I was working always within a month or two to deliver my judgments and also my decisions. After I have not given reasons, once the reasons are requested, I put them in within 2 weeks of such an application being lodged by parties.
Thank you, Advocate. Thank you, Chief Justice.
Chief Justice, could I add my name? Could I add my name to the list?
CJ?
Yes, please, CJ. Could I add my name?
Yes.
I missed the boat, sorry.
All right, okay. Prof?
Thank you, CJ. Good afternoon, Mr. Kumalu.
Good afternoon, Professor.
I want to take you back to your foreign qualification because that is a great concern to me.
Yes.
And I must tell you why. Your legal qualification in Nigeria is based, Nigerian law, as far as I understand it, is based on common law.
Yes.
That is the British common law, which you write with a capital C. South African law is based on Roman Dutch law with huge influences of Roman law. And our common law with the small c is totally different from the common law of England and the common law in Nigeria then. To me, that means that you don't have had the exposure to our South African common law. All the things that you've said up until now in this interview and also in your documentation doesn't indicate to me that you didn't say anything that you tried to familiarize you with the South African law sources. And there are quite a number of fields in South African law that doesn't have anything to do with British common law, such as law of succession, property law, contract law, specifically prescription, matrimonial property law. Most of our private law does not have any links with common law. Can you tell me what you have done to familiarize you with South African law?
Dear Professor, I've been practicing as an advocate of this country for 14 years. I pay my bar fees and I'm not broke. It means there's something right I'm doing. If you look at the decision of Sanan against ESCOM, I took a very unusual exception, and it was upheld by the High Court. And it saved ESCOM in excess of about 40 million, which was claimed in such a matter. And I am instructed by some of the best attorneys in one of the busiest divisions, and I practice common law. I practice South African law. As a jurist, what is important, I don't think we should debate what, it's like saying to a colonized person, you are not colonized enough in Roman and Dutch law, so you cannot actually practice in South Africa because you should have first gone through this colonial training in order for you to be suitable. That's a fallacy. The fact of the matter is that if you know how to ride a bicycle, you'll ride it anywhere in the world. I am a South African practitioner. I've studied South African law. I'm a voracious reader. I am a fast learner. And I've been able to apply my skill in this country for more than 14 years. If I wasn't coming before this court, I would probably be demanding certain statuses in the profession to show that I am not the best, I'm one of the best. So it's very easy to sit and look at the four corners of my CV and say, you are foreign trained. I have mentioned at the beginning of my interview that I wrote a complex judgment against Caltex. It went to the Supreme Court of Appeal. It was upheld. Now, I don't know if the top six is happy with me. I'm happy.
Follow up, CJ, please.
Follow up, CJ, please.
I've got Commissioner Mpofu, was it Honorable Magwanisha, who also wants to follow up?
Yes, Chief Justice.
Okay, SC, you go first.
Okay, I'd rather slip here. Thank you, CJ, yes. Is it even true that the English common law is not part of South African law? With the capital, the one with the capital C. Is our law of evidence not almost a complete transportation of English law? Our law of insurance and many disciplines, and even the law of contract that is being referred to by the learned professor. Where is this distinction made? Of course, our common law has roots in Roman Dutch law, but when you apply the law, you rely on Wigmore and people like that who come from the common law with the capital C. Isn't that the correct position?
It is correct. I think I'm thoroughly embarrassed by such a debate, to tell you briefly. Because, I mean, you cannot say to somebody who has been practicing in a jurisdiction for 14 years, has been found to be fit and proper and capable to become a judge, to act not only for one stint or 6 weeks, for 6 months, to be appealed and upheld. What else can I add to that litany of achievements?
Who is an African?
Who's an African, who has been abroad because of historical circumstances, to come and say, because of all this, I think you're not competent. So it's almost like I was a lecturer. I'm practicing law for a living, and I'm doing well. There must be something right, I know. I know a lot of professors that cannot stand their own in a court of law. We would need to take such academic through some form of training in order for that person to become a competent practitioner in a high court. So it would be very, I don't think it's a tidy argument. It's fallacious, because if I was not, when you're a judge, you are being judged. When I write a judgment, I'm anticipating to be countermanded by academics, to be appealed by judges. So when I judge, I'm being judged. And I have been judged. I can't be judged now about my competency. That past is long gone.
Okay, so, sorry, CJ. This is what Wikipedia says about South African law. South Africa has a hybrid mixed legal system formed by the interweaving of a number of distinct legal traditions: a civil law system inherited from the Dutch, a common law system inherited from the British, and a customary law system inherited from indigenous Africans, termed African customary law, of which there are many variations depending on the origin. The traditions had a complex interrelationship with the English influence, most apparent in procedural aspects of the legal system and methods of adjudication, and the Roman Dutch influence, most visible in its substantive private law. As a general rule,
Chief
South African
Justice.
laws, English law in both criminal and civil procedure, company law, constitutional law, and the law of evidence.
Let me just make one remark, if Chief Justice,
I think somebody wanted to say something. Go.
Chief Justice, yes, I just want to come in. If I may come in here, Wikipedia is definitely not an authoritative source of South African law.
I am.
And that's definitely not something that we should be quoting here. If we want to quote authority as to the status of...
I think that, okay, Prof, you will have your follow-up comment. Let
Thank you.
Advocate Nxumalo finish his answer.
I just wanted to complete the answer by saying, I am proud that you might go around the country in most universities, you are most likely to find a Nigerian law professor who is Nigerian trained. So if we are good enough to teach South Africans law, we must know South African law.
Chief Justice?
Prof, I see that you and Commissioner Mpofu are not questioning the candidate now. You are seeking to validate your own viewpoints to the candidate. And we should really be testing his intelligence. I will allow you so that you even up with Commissioner Mpofu, but this is not in line. What you and him are doing is not in line with our way of doing things.
Well,
Chief, because of ads in this case, I will allow you.
Yeah,
And
Chief
it's
Justice.
1 o'clock already.
Chief Justice, yes, I apologize for that, but I think the public should never be left with an impression by a particular question that something is factually correct when it is not.
No, I understand that. What you could have done was found a way of putting a question to Mr. Numa so that he, as a candidate, is the one providing an answer.
Yes, that's what I did. Thank you, Chief Justice.
Give Prof chance, CJ.
Chief Justice.
No, I'm giving you a chance, Prof.
Thank you very much. Mr. Nxumalo, you haven't allayed my fears, in essence, that you are not qualified for private law. I specifically spoke about private law because procedural law, procedural law, public law has huge influences of common law, but not our private law. I don't know whether you are aware of South Africa's schedule of specific commitments to the WTO, where we open up our legal services to foreign qualifications or to people with foreign qualifications. In those instances, people with foreign qualifications are only allowed, in terms of our international law obligations, to present legal services in South Africa if it is for international law and foreign law only. So it's different the way in which we perceive our status at the international level, but that is not the question. The question remains, have you read up on family law, on succession, on contract law, on property law, whilst you've been in South Africa, practicing in South Africa? Because none of the cases that you attached to your application and none of the things that you have said indicated that you have dealt specifically with private law matters like succession. When you are appointed as a judge, you will be exposed to these matters. If you have to write a judgment and you are not au fait with the principles, it's going to potentially delay your judgment because you will have to read up more. And that is why I'm asking this question, whether you have, up until now, done courses, for instance, in some of these fields.
I have practiced every aspect of South African law lucratively and successfully. I am a good researcher, and I'm a competent practitioner. So I don't see any difficulty what I would not be able to do from the bench, which I've been able to interpret and practice in South Africa. In the nature of things, one of the quality control of the capability of an advocate is that he's not briefed by lay people. He's briefed by lawyers like him. So an advocate would be a lawyer's lawyer. So I have done all those for my colleagues, and they paid me for that. And they've been doing that for 15 years. I am competent. I can assure you that.
Thank you, CJ. I'm not convinced, I must say.
That's okay, that's fine.
Thank you, Prof. Honorable Magwanisha, you also had a follow-up.
I generally think, Chief Justice, I will be detaining this commission unfairly, but I totally disagree with the professor. Thank you.
I also disagree.
No, that's fine. Disagreement we can deal with during deliberations. Commissioner Dlepu, Matolo Dlepu.
Okay, thank you, CJ, and good afternoon, Advocate.
Good afternoon,
You know,
Commissioner.
your story fascinates me, and I'm very jealous that you're moving to the Northern Cape. And I just wanted to hear from you this artificial difference between the two bars and sidebars, especially coming from from the Nigerian environment. Don't you think is the one that's actually, what do you think about it? Number two. The second thing, what I want to find out, this perpetuation of the British common law, how do we actually erase it from South Africa?
I think we should do what the Americans did in 1775 after the American Revolution. They restated British law as American law. So they just removed the chaff and remained with the grain. Things that they did not want, and so you have what you call American restatement of the law. So we need to go and shake every tree and see what falls off, what do we need, what we don't have. And it is that transformative constitutionalism we're talking about. As far as the dichotomy of the legal profession is concerned, I think it should not be regulated by an act, whether or not I'm an advocate or a solicitor or an attorney. I should decide what is my specialty, but I must have a skill set which can make me either to become an attorney and make me eligible for. So the training has got to be more inclusive. There should be one LLB and there should be a curriculum going forward that trains advocates and attorneys in the same way, so that when you come out, you are able to, I can sit here and speak conveyancing until the cows come back home, because I have been trained as a solicitor with conveyancing aspects. So it should be more like you have personally choosing that I want to just do notarial work, I just want to do court work, I just want to do work as a solicitor. And those nomenclatures and differentiation will be more out of preference instead of you having been admitted as an advocate. And it would go towards the unification of the profession.
Thank you, CJ, and thank you, Advocate. Don't follow.
CJ.
Thank you, Commissioner.
CJ, is Commissioner Gogo.
You are doing follow-up. Okay, Commissioner.
Yes. You spoke of fusion, the way you did. I'm happy, but I've reserved. I thought Commissioner Lebu was going to ask you as well about your good standing with the LPC. If you are in good standing in terms of subscription, as well as if you are in good standing in terms of complaints against you. Thank you.
On both counts, subscription, and there is no pending investigation or disciplinary proceedings that is against me.
Thank you, CJ.
Thank you very much, Commissioner Sigoro. Commissioner Barnard.
Thank you, Chief Justice. Judge Kumalo, given, I want to step away from the common law debate, because you're also an expert in inquisitorial law. And so I want to just hear, how does that affect your adjudication of disputes in the mainly sort of adversarial court? And what is your view? Are your views on judges descending into the arena during hearings?
The Commissioner Bernard, when you conduct an inquiry, obviously your role as a presiding officer would be informed by the very process of the inquisitorial demands and the powers that you have. Descending into the arena for a judge in an adversarial adjudication is not desirable because at the end of the day, the judge does not become, or the judge, when he does so, would becoming a player and a referee at the same time. So there are certain stances or postures that these two presiding officers must be seen to adopt in order to distinguish one process over the other. I am done, Commissioner.
Thank you very much. Thank you, Chief Justice.
Thank you very much, Commissioner. Honorable J.P. Mlambo.
Thank you, Chief Justice. Ndwandwe, I just need you to clarify two things for me. It's very broad. One is, should I understand your responses to the JP's questions that when you failed to get admitted in the Northern Cape because of failure to meet the requirements as identified by Judge President Homo in his judgment, that your application in the Western Cape Division was compliant?
Yes.
Thank you. Because you see, I raised, so you say it was compliant?
Oh yes, it was a function of saying, what is the issues that have been raised? Address them.
Yes. Now, the follow-up question to that is, why didn't you go back to the Northern Cape?
I cannot really give it a direct answer at the moment, but I think one of the things is that I was angry. I didn't like the way the whole issue. Courteously, JP, if your society has got qualms with your application, they would approach you as a colleague and say, look, this is our difficulties. How about curing it?
Yeah.
So I had there were some unarticulated paradigms in that opposition.
I see. No problem. I just needed you to clarify that, and thank you for clarifying that.
Thank you.
The other one is, the other question, CJ, is linked to this. You've clarified it and accepted, but I'm talking to you about what's happening in South Africa now. You go to a division, you lose, you go to another division, you win. There's a narrative that says members of the ANC don't win in one division, they win in another division. I'm here representing other heads of courts. It worries us. Linked to that are the attacks on the judiciary, right? You've offered us a lot of ideas to think about, and that's why I'm asking you this. It's not every day we get a candidate who has had his formative years in the trenches, in exile. And you've offered some ideas, and that's why I'm testing this with you. So, what is your view about the narrative that says there's judicial capture, and the other narrative that says these attacks on the judiciary are weakening the judiciary and therefore a threat to our democracy? Because you want to become a judge, you want to join this judiciary. So I just want to determine your thinking about these issues.
Thank you, JP. Starting at the end, judicial capture for me is too vague because there are mechanisms. If a complaint has to be laid against the judge, and it will go through the adjudicatory processes until it is determined whether it has merit or not. But it's a very ambitious exercise for anybody to embark on because of the checks and balances. If you were to bribe a magistrate and your opponent appeals to a full bench, you'll have to bribe those two judges, and then your appeal goes to let's say to
the full court of three
or five. You'll have now to bribe all five of them, but you'll first have to know who's going to be part of that panel when the matter is adjudicated in Bloemfontein. By the time before the ink on your bribery check is dry, you have to bribe again 10 judges in Bloemfontein in order to influence the outcome. So I think it's next to almost very difficult to really achieve a judicial capture because of the inherent checks and balances. And judgment writing, you articulate and communicate to the parties, the Supreme Court, and public society as to how you got here. And if people don't know how you got there, the academics are sitting on the wings to criticize your judgment. Your colleagues are there to criticize it, and the Supreme Court of Appeal is there to scrutinize. So the element of scrutiny is a check against any. I've given you the mechanism through which a judge should be scrutinized if any allegation is made against such a person. And on the other side, you should be having the inherent system of stare decisis, ratio decidendi, and other jurisprudential mechanism to ensure that our decisions are consistent, predictable, and are up to scratch in scrutiny. So the Judicial Service Act has got also a mechanism that determines that you must go under oath if you are having any complaint against the judge. It shouldn't be on social media or based on newspaper cuttings. It should be stated under oath so that those allegations can be attested. There is also the criminal system which you can use, because a judge is a simple citizen of South Africa, and if he's involved in corruption, he or she is also equal before the law like any other member of the society. The attack against the judiciary, it comes with the terrain. whenever a party is unhappy about a decision, so the tendency is to tackle the man instead of tackling the ball and tackling the woman if it is banyana banyana. You know, so we should have that thick skin. As judicial officers, we should understand that the nature of the job is an occupational hazard of being criticized. So you must be able to stand up to scrutiny and to be above reproach and impeccable and very, very industrious in how you communicate your judgments, how you research them and reason them, so that even your best pundit should give you a pat on the shoulder. Forum shopping is what people think that, no, this division is not going to be in my favor, so let me go to this division in order to see how it is going to be, what have you. It doesn't follow that a change of jurisdiction and or a trend in a particular jurisdiction necessarily means that certain judges in one division are opposed to other judges, are opposed to a particular party in another division. I think if a proper analysis is made as to who has been ruling against who, we will find that everything turned on the merits and not as to who was before the court.
See. Thanks for that clarification. One little follow-up, CJ. You say the judiciary must have a thick skin. South African society is a very gullible society where people come to court and lose. The first thing they say is those judges were bribed. You have a list that keeps surfacing that says Judge so-and-so received so much, Judge so-and-so received so much, Judge so-and-so received so much. Mostly by people who are faceless, who are on social media. Only in recent times did certain people identify themselves propounding the same allegations. Should we still have a thick skin about those? And I think, because I'm just responding to that, should we have a thick skin as a judiciary? And you don't think the gullibility of South African society isn't where the foundations are for weakening the efficacy of the judiciary when allegations like that are made?
Oh yes, Judge President, I understand the invidious position that you judges have to occupy, because by merely not being able to rebut a rumor, there could be some element of authenticating it in some way. Perhaps there should be a structured approach from the Chief Justice Office to throw down the gauntlet in a clear statement to say anybody who has any information, and I think I'm almost quoting him, I think he has said it before.
He has done that.
He has done that. And a time limit must be put to say it should be done within 30 days. And after which, keep your peace.
Okay. Thank you, Dwandwe. Thank you, CJ.
Follow up,
CJ. So
CJ.
much time.
Honorable Malema, please proceed.
Advocate, this judicial attack, when does it become a judicial attack? Because if it's Klope, if it's Mokhwe being attacked, it's not called a judicial attack. It is something else. But if it is some favorites of the establishment and are being criticized, it is called a judicial attack. And who makes it, who characterizes it as a judicial attack? Who sits there and decide this one is a judicial attack, this one is not a judicial? When does it become a judicial attack? And when should the Chief Justice release a statement in defense of judges that are being attacked? I just gave you an example with two judges, Klope and Mokhwe. When they speak not in favor of the establishment, they are being attacked, and it's not called an attack. When people judge here and judge wrongly and get overturned half the time and they're being criticized, it's called a judicial attack. When does it become a judicial attack, and who decides it becomes a judicial attack?
any society will have a common denominator. Sometimes the common denominator might be pushed by a majority to say, this is our perception and our view. However, societies such as ours, with their protracted history, there is sometimes what you will have the dominant narrative, which does not necessarily come up as a result of a general point of view, but because of the efficacy of the method that the other group is articulating and expressing its views. And that would be named to be the most popular point of view. So I think without the judiciary being very involved, we have organizations out there that are vocal, and they should come out clearly and in order to protect the judiciary. The judiciary must be protected, Mr. Malema, because it is one of, in its power, it also has its weakness. It doesn't have a police force. It doesn't have soldiers. It depends on all the other arms of government to be able to operate efficiently. So the frontline defense to the judiciary should be the civil society, the political society, the executive, and the legislature. And that is why a supplication to the executive to protect the judiciary was properly made at one stage. I don't know whether it's 2 years ago, by the Chief Justice and heads of court. But I'm saying it should not be a once-off event. It must be it needs to be, people need to be reassured that the executive will always protect the judiciary will do its duty, and that there are checks and balances in order for judges to remain above reproach. Because it is simply when a judge has been bought, if you were to ask a law student whether or not he or she believes that proposition, he will tell you, no, I don't think so, because I've just given you how the checks and balances are. One magistrate, you buy the magistrate, you buy 2 judges, 5 judges, 20 judges, and you have to first know their identities before you can even do the EFT or whatever means of corruption or medium you want to bribe them through. So we are in the hands as a judicial arm of the good faith of the society, the executive arm, as well as the legislative arm.
So are you saying judges cannot be criticized? Because judges are human beings.
No, they must be criticized. It is an open democratic
Because there's
society.
something, there's a difference between making an allegation of bribery, and there's a difference from criticizing the judiciary or the judges themselves.
Oh, yes.
And
no.
from time to time, society engages in the critical debates, and which amongst others will include whether the judiciary has been transformed, whether judiciary it is where we want it to be, and how do we get it there. We cannot arrive at a conclusion that we are where we want to be if we are not allowed to critique the judiciary. Am I correct?
I am totally with you, Commissioner Malema. Anybody who cannot expose himself or her to criticism has got something to hide, because justice can't be conceived in the dark.
Thank you, CJ.
Can I make a follow-up?
And thank you, Advocate.
Thank you.
Thank you, Honorable Malema. There's a colleague who wants to make a follow-up.
Is Cyril Klaba.
Yes, Honorable Klaba.
Thank you very much. Good afternoon, Judge.
Good afternoon, Mr.
Yes,
Klaba.
I'm making a follow-up.
It's flattering. You're calling me a judge.
Oh, sorry. my apologies. Is it proper for a member of parliament to unfairly attack a judge on a public platform when he or she has a legislative platform to discuss issues pertaining to the judiciary? I'm raising this in the context of the 3 arms of government.
Honorable Kaba, I'll allow him to answer your questions, but please, colleagues, don't forget our undertakings. We made certain promises to ourselves, and I'm not too sure we follow through on that.
CJ, I understand your request. I just want to have one follow-up question.
Yeah, I also understand the follow-ups, yes. I will come after answer advocate. Because then it becomes something else, Honorable Minister, but you'll have your opportunity.
Dear Commissioner, I think there is a reason why Parliament has got rules, and one of them is about the indemnity of some immunity that you have when you speak in Parliament and when you perform in the course and scope of your duty. So it is there that you have, you perform your your legislative function as a lawmaking body, and you take into cognizance judgments to determine as to what our law can be amended and how it must be amended and how the courts have pronounced it. And I think judges write very well. They have enough time and resources to write, and if they have opinions over and above their ratio decidendi, they can go obiter dictum. But when they do so, they should understand that it can't be a gratuitous attack on things that you disagree with in society as such. So there should be this healthy tension, and I say healthy tension because there must be tension. In the nature of things, these three arms are designed to overlook, oversee, commingle, and intermingle. So there will always be a jurisprudential debate as to exactly which one has trembled into the space of the other. But I think if we understand that criticism must be constructive, and I use criticism as opposed to what you have said, attack, because that would be malicious, it imputes intention. But criticism is a bona fide disagreement with a decision that a judge has made because you have other perceptions of how those facts could have been interpreted.
Thank you very much, Advocate.
Thank you.
Honorable Minister.
Yeah, thank you, Advocate. You partially answered my follow-up question now at the end, because I want to ask you a very simple, crisp question. Can you differentiate between a personal attack on the person of the judge and the criticism of the decision of the judge?
Oh, yes. You'll see there will usually one of the first things I have realized in order to distinguish a personal attack is that is done immediately the judgment is handed down, or so soon thereafter that it is reasonably and unreasonable and impractical to assume that that person has read the judgment. Whilst you as a lawyer are still trying to get the judgment to see exactly what's wrong with it, a lay person at the doorstep of the court already knows what is wrong with it. That is not a well thought through argument. And the other element is that it is a fallacy ad hominem. It normally attacks the judge, not to discredit his finding, but to insinuate certain extraneous, fallacious, and malicious events that could have stirred him towards the decision either in favor or against a party. So note very well, quick reactions to judgments are always sometimes wrong because you need to go and study and research. No matter how genius you are, in order to say he has overlooked this ratio in this case, he's not consistent in this case because he decided to underplay these facts.
I'm covered there, Advocate.
I thank you.
Thank you, CJ, for your indulgence.
CJ.
Thank you, Honorable Minister. Is there another follow-up?
Is go CJ.
Is there a follow-up or just a different one, Honorable Sigogo?
No, it's to clarify the issue I asked with the candidate.
Okay, sir. Please go ahead.
Thank you. Advocate Nxumalo, I verified with the Legal Practice Council that you are in good standing both in terms of subscription and conduct as on the date of application, particularly on subscription. So I'll need this to be clear because this is publicly televised, so people must not doubt your standing. Thank you.
I thank you, Commissioner, for your...
Thank you very much, Commissioner Sigogo. Advocate Nxumalo, thank you, sir. You are excused.
Thank you, Chief Justice. Thank you, Commissioners. Thank you, Prof.
That was.
Good afternoon, Ms. Nader.
Good afternoon, Chief Justice.
Are you well, ma'am?
I'm very well, and yourself?
I'm very well, thank you. I apologize for keeping you waiting.
It is no problem, Chief Justice.
Yes. Tell us about your degree. Which degree did you obtain when?
Chief Justice, I obtained my LLB degree in 2002 from the University of the Free State, and I obtained my master's degree in 2003 from the same university.
For your master, was your master's program plain dissertation, or did you do it through coursework?
At the time, I was given the opportunity to do it through coursework, so it was not a plain dissertation.
So which courses and what was your short dissertation on? Because there's normally a short dissertation at the end, in addition to the coursework that you do.
Chief Justice, at the time, we had the option to take only coursework combined with the dissertation or a dissertation. So I'd taken only the coursework. The majority of my coursework was focused on criminal law.
What about the minority?
The minority was focused on labor law, Chief Justice.
Yes. And what have you been doing all these years? And how has the practical work you have been doing, coupled with your acting skills, prepared you for the position of judge of the High Court that you have applied for?
Thank you, Chief Justice. When I had obtained my LLB degree, I returned to Kimberley and I started my articles wanting to stay in the Northern Cape and plow back my skills into the province. In 2005, I was admitted as an attorney, and a few short months later, I joined my current firm as a director, where I served as a chairperson of the board for a number of years, and I'm still at the same firm. Having had those opportunities to represent my firm as chairperson, I have obtained managerial and leadership skills, and I had also then completed I was admitted as a notary, as well as a conveyancer. I was requested by the then Judge President Homu in 2017 to act, which I did from January to December in 2017. And I was then invited back by JP Tlaletsi to act for the first term of 2021. And I'm also currently acting now for the second term. I had also represented the Consumer Protection Court. Well, not represented, but I was on their board. And when the then chairperson of the Consumer Protection Court resigned, I was requested by the CEO to act then as the chairperson of the Consumer Court. All of these factors over the years have led me to obtain certain skills. I've got the necessary experience from everything that I have done, and also the maturity for this position. But added to that, I also have the energy for the job, Chief Justice.
Thank you very much. Colleagues, before I hand over to the JP, may I have the list, please?
Matolo Lepu.
Matonsela. Nyambi. Lamola.
Tepe.
Schlemmer.
Barnard.
Over to you, JP.
Thank you, Chief Justice, and good afternoon, Ms. Snyders.
Good afternoon, JP.
Yes, just two aspects that I want to take up with you. Just to give us an update on your form relating to the judgments that have been appealed against. You indicate out of the 6 that the 3 has been upheld, the appeals were upheld, and the others you say still outstanding, the other one still outstanding. So if you could indicate, or the other one is unknown, what is the position with the other 3?
JP, as JP had said, 3 of the 6 were upheld. The one I was unable to find, the one where I'd indicated as unknown, I'm unable to find the status of that appeal. I'm not sure if it was ever finalized or if it was actually placed before the court to be argued. I cannot find any indication of the outcome of the one. And then the other 2 are still outstanding, JP. They still need to be placed on the roll to be argued.
Oh, I see. And then how is your relationship with the practitioners in Kimberley?
JP, I have a very good relationship with the practitioners in Kimberley. I have been an attorney now for about 16 years, and I have not encountered many problems with any of the practitioners. I have to say that I think that I've earned the respect of my colleagues, and so my relationship with them is good.
I see. And then on your social responsibilities, I see that you were the chairperson of the SGB, school governing bodies of the 2 schools, and you're also involved in the Rotary Club. Is that limited to that, or there are other things that you may need to update on your questionnaire?
No, JP, it was limited to what I put in the questionnaire, serving as a SGB member of a primary school, my apologies, and then also serving as a co-opted member of a high school, and then, of course, my participation in the activities of the Rotary Club of Kimberley.
I see. Thank you, Chief Justice. Thank you, Ms. Snyder's.
Thank you, JP.
Thank you, Honorable JP. Honorable Premier.
Thank you very much, Chief Justice, and good afternoon, Ms. Snyder's.
Good afternoon, Commissioner.
I just want to ask you, around the panel, you've got 15 men and 3 women. What's your attitude towards that?
Commissioner, my attitude towards that is that it is probably reflective of a lot of what is happening in our society. Fortunately, not at our bench at the Northern Cape High Court, but probably in other areas of the judiciary as well. And then I was the only female attorney in the Northern Cape asked to act on the bench. So it is indicative of what the current standing is in society at the moment, I think.
Okay, my second question is, what's your views about the right-based approach to law in addressing past injustices, which basically include gender inequality and all of that?
Thank you, Commissioner.
And how do you think, if you get appointed into this position as a judge, you'll be able to use that as an instrument to advance this agenda, the agenda for gender equality?
Thank you, Commissioner. I think that a right-based approach is imperative in our judicial system because the rights that we have come from the supreme law of our country, being the Constitution, and that has to be implemented. It is disheartening to have seen, especially if you speak about gender inequality, looking at the increase of our gender-based violence in South Africa at the moment, which is probably what would be called a second pandemic. And what I have seen is that probably we need to develop the law on this to an extent that there is possibly more uniformity in how these cases are approached. So looking at our jurisprudence, I would want to turn to the decisions taken by our higher courts in order to apply the findings that were made there to improve the sort of uniformity in coming to decisions on these cases.
Thank you very much, CJ, and thanks, Ms. Snyder.
Thank you, Commissioner.
Thank you, Honorable Premier. Commissioner Matolo Zebu.
Thank you, Chief Justice, and good afternoon, Ms. Snyder.
Good afternoon, Commissioner.
One of the things I normally get excited when I see female attorneys applying for the bench, So I'm quite impressed. But one of the things that I see, I wanted to find out, how do you network? I don't see any organizations like except the Law Society. Because I'm asking you this question because the Northern Cape, for me, is still a bit, it doesn't reflect the demographics of the country. And what can you do yourself? What did you do all along to embrace the other attorneys, of color or white? Because normally, we thrive by belonging to organizations. You exchange ideas, you network with your fellow sisters there. That's how you know who's been admitted yesterday, whatever it is. So I just wanted to understand, how do you do it? You know, are you a solo, or do you feel that you need to network? You know, I don't see it in your,
Thank you,
application.
Commissioner. I do think that networking is important. It was probably a slight on my record that I've not belonged to as many institutions in order to network. But when we speak about what do I do in terms of my fellow attorneys, I belong to a law firm where I was the only female director for a number of years. And since I've been there, we are 4 altogether. And I think that I've played a role in changing the demographic of our board of directors from 1 female, majority of males, to where we are now a majority of females on the board of directors. What I also have seen is that I have, as JP had asked me about my relationship with my fellow legal practitioners, I have a very good relationship with them, especially the women. And I find that they come to me often for assistance, whether it's to bounce off ideas about a case they have, or assisting them in drafting a document, or asking for advice on what they should be doing with a case. I have been there. They freely approach me, and I offer them assistance whenever and wherever I can. When I preside over cases in the High Court, especially motion court, I don't know if this will come across the right way, but I do try to have a slightly softer approach with your female attorneys, especially the younger ones or the female practitioners, because you want them to have the courage to come to court, to start honing their skills. You want them to come to a place where they are comfortable, where they know that they are not going to be humiliated or degraded, that they would be assisted in moving their matters. Not to say that you will grant them the applications, but possibly point out where they should be improving or what should be done, so that when they appear before your next brother or sister, the applications can be granted, which improves the efficiency of our courts, but it also gives them a bit of confidence to come there and stand and do their own matters. Regarding my fellow female directors at the firm, I have been there, I think, as a source of strength for them. When you are a group of people in an association, you're bound to experience conflict. And so I always try to encourage them to put their viewpoints across, to stand up for themselves, and to realize that they have a voice and that they are important in the positions that they have.
Follow up, I'm asking this question because I know that the scourge of gender violence in the Northern Cape, and it's very high. And what I expect from our fellow, because I'm an attorney, is to try and go out and really make sure that our people are being assisted, especially our women. Do you participate in such? Did you ever participate in those type of?
Thank you, Commissioner. There is a company that provides leadership training, amongst others, to a specific group of women in mining in the Northern Cape. And for the past 3 years, they have asked me to be a guest speaker at the conference that they have with these women, specifically to address sexual harassment in the workplace, and then also attitudes and perceptions of women in the workplace. So yes, in that way, I have participated.
Thank you.
Follow up, CJ.
Thank you, Commissioner.
Please follow up, sir.
Thank you. The Black Lives Association and NADEL are organizations within the legal fraternity which are known to champion the interest of Black legal practitioners and, most importantly, women. Do you see value in those organizations?
Do I?
Do you see value in those organizations? Thank you.
Thank you, Commissioner. I certainly do see value in those organizations. And as I said, it might be a slight on my record that I've not belonged to as many institutions as I could have or should have, but there definitely is value in those institutions.
Thank you, CJ.
Thank you, Commissioner.
Thank you, Commissioner Segogo. Advocate Madonsela C.
Thank you, Chief Justice. Good afternoon, Justice Neros.
Good afternoon,
Advocate Neros,
Commissioner.
One of the objectors who objects to your appointment describes you as, and I quote, one of the worst racist person who have no regard and respect towards black people, unquote. Any comment?
Thank you, Commissioner. The allegations that have been raised by the unknown author of that letter is completely untrue. Discriminating against black people would be a form of self-hate. As a colored female, on what basis would I ever treat anyone of a different race as less than myself? Those allegations are not true.
As an acting judge, do you see, what is your view about, and have you ever delivered any extempore judgment in an opposed matter in court?
Thank you, Commissioner. I believe that I may have on 2 occasions in urgent applications delivered extempore judgments, but all of my other written judgments, all of my other judgments were written judgments.
Thank you.
Thank you, Commissioner.
Honorable Nyambi.
Afternoon, Ms. Snyders.
Good afternoon, Commissioner.
As you want to be a judge, if you can share with us 2 attributes of a good judge and those that you think you possess, given what has been said by the people of Kimberley.
Thank you, Commissioner. I think looking at the comments that were said by the, as stated, unknown members of Kimberley, one of the attributes that I do possess is humility. And that is an important attribute of being a judge, because you have to accept that you are there to serve the litigants and to not put yourself in a position where you are treating people in a manner that they should not be treated. You should be treating everyone with respect. And then the other attribute that a judge needs to possess, and that I think that I do, is maturity, because you need that for this job in order to keep your emotions in check and to not let them overrun your intelligence.
Thank you, Ms. Snyders. Thank you, CJ.
Thank you, Commissioner.
Thank you, Honorable Nyambi. Honorable Minister.
CJ, I'm covered. I wanted to ask the question that Councillor Madonsela has asked. Thank you.
Thank you, Minister. Commissioner Tsepe.
Thank you, CJ. Good afternoon, Ms. Snyders.
Good afternoon, Commissioner.
I just have 2 questions that I wanted to ask you. One is whether, other than your acting stints at the High Court, whether you have any other adjudicative experience that you believe would be relevant for a role as a judge were you to be appointed. And if you could say why you think that experience is relevant.
Thank you, Commissioner. The other adjudicative experience I have is as a board member and as a chairperson of the Consumer Protection Court. I have presided over and adjudicated over matters in terms of the Consumer Protection Act as a member sitting at a single court, and then also part of an appeal process at the Consumer Court. And this is invaluable because this act is becoming more and more widely known and more widely used by the public. And I do expect more review applications to be coming from the Consumer Court to the High Court.
Thank you. My last question relates to a production or timeous production of judgments. Have you had any matters where, or how soon have you delivered your judgments in the High Court? Have there been any challenges that you have experienced? And if so, what were they and how have you resolved them?
Thank you, Commissioner. I do not believe that any of my judgments had been outstanding for longer than 3 months, save for one. There was a criminal trial that I had presided over in 2017. There was a criminal trial I presided over in 2017, and an application for leave to appeal by the accused had been lodged within the time frame after that judgment was delivered. This was only brought to my attention probably in August of 2020. So that is one challenge that I faced, where I was not made aware of that application by the registrar, but it is an anomaly in our court. That is not the norm. So I don't think that I had really taken any other steps besides talking to the registrar about this particular matter, because, as I said, it is an exception rather than the rule. But once I became aware of that application for leave to appeal, it was finalized within the 3-month period.
Thank you, Chief Justice. Thank you.
Thank you, Commissioner.
Thank you, Commissioner Tsepe. Commissioner Barna?
Thank you, Chief Justice. Good afternoon, Ms. Snyders. I'd just like to clarify one thing. On page 6 of the application form and page 7, where it asks about the proportion of the work, it seems to, you indicate a percentage of 210% there. So I think there's maybe just a misunderstanding or something. So just if you can just maybe give us a clear understanding of the proportion of your litigation work, in what field it be.
Thank you, Commissioner. The basic field that I find myself held up with the most is civil litigation in our High Court, which ranges from opposed motions of various natures and then also trials, and then of course the divorces and the liquidations.
So all of those areas that are mentioned there, you do cover, you have dealt with it to some other extent in litigation.
That is correct, Commissioner.
Thank you very much, Chief Justice. Thank you.
Thank you, Commissioner.
Thank you, Commissioner Barnett. Thank you very much, Ms. Nice.
Sorry, CJ, I think you forgot me.
Oh, I didn't have you. Go ahead, Rob.
Thank you, CJ. Apologies. Good afternoon, ma'am.
Good afternoon, Commissioner.
I would just like to know from you what your judicial philosophy is.
My judicial philosophy is that as a judge of any court, you need to adhere to the core values of integrity, impartiality, and independence. And those three are what I have adopted as my own philosophy in being a judge of the High Court.
Thank you very much. Perhaps just a second one. What is your perception or understanding of the rule of law?
My understanding of the rule of law is that with the Constitution in place, that is the underlying basis for any decision and any application, any development of the law in our country.
Thank you very much. Thank you, CJ.
CJ?
Thank you, Prof. Honorable Malema.
I'm covered.
Thank you, Commissioner.
Thank you so much for your excuse me.
Thank you, Chief Justice.
Thank you. May the room be cleared, please, administrators, so that we can begin the deliberations.
That was 42 minutes. 42 minutes.